One of these days, appeal from decree will be placed above appeal from orders, and then your items are the first three items.
Very well. I'm mentioning upon notice.
With your lordship, I was also mentioning upon notice, the bunch of specially assigned matters that 89 to 93 on the point of reciprocal obligation, which your lordships were hearing, that in which the mediation, we have tried before the executing court in Rajasthan. Our section 47 application has not been allowed, and they are executing the same property, my lord. If we can get some precedent next week, my lord.
Let us see, Mr. Next.
Because the assigned category has gone down this week, my lord. Yes.
My lord, in my case, an order has been obtained from the tribunal, that is lower court, city civil court, by defrauding the whole thing. That is, the loan was taken.
What do you want, madam?
My lord, an urgent hearing for tomorrow, as because 5th is fixed for taking possession by the receiver.
What? You filed an appeal?
Yes, I have filed an appeal, my lord.
Very well. It will be taken up in due course. Next.
Lord, may I have lordships kindly to mention a section 37 appeal. Lord, I am humbly praying for inclusion.
Inclusion, just hand over the slip. Please don't mention. Just hand over.
My lord, may I be permitted to seek your lordship's leave to file a cross objection without certified copy, my lord? The main appeal is returnable on 10th, my lord.
You have applied for certified
My
copy?
lord, I have applied.
When was the order passed?
My lord, order passed on 15th of July, but my lord, we have received the appeal on 12th of August, my lord.
My lord, may I be permitted to mention, my lord, to file an appeal without a certified copy? My lord, order dated 28th August 2025.
My lord, may I mention again that is
No,
our
please don't. You
5th
told us.
schedule for taking possession, my lord.
Yes.
My lord, I am seeking leave to file this appeal without certified copy, my lord, and to move it tomorrow, my lord. There is some urgency. An order has been passed by the commercial court, Alipur.
Have you filed the appeal?
My lord,
You have not yet filed the
I am
appeal.
seeking leave to file it without
appeal.
certified copy.
Yes. When was the order passed?
My lord, yesterday, 2nd.
Very well. Leave granted. Serve. It will be listed.
My lord, I have moved the ex parte injunction before the commercial court. I will be moving it ex parte only.
Very well. Do that. It will be listed, and then we can't say anything more. We can't promise that it will be taken up tomorrow. We cannot promise that.
There is some urgency, my lord.
In your learned friends matter also, there is urgency.
My lord, an urgency.
Sorry. Heavens won't fall. Copyright infringement. Chalo, next.
Lordship, I am mentioning upon notice.
Copyright infringement.
Lordship, I am mentioning upon notice. My learned friend is also there. Lordship, these are two appeals which would be coming up, Lordship, tomorrow in the appellate side commercial division. Lordship, I was being led by Mr. Shuman Kumar Datto. Tomorrow he is unavailable. Lordship, even I wouldn't be a little.
So very well, mention tomorrow and tell us. They are not there in the list today.
My junior.
Mr. Sen,
I'm
Vilajan. Tomorrow, tell us.
I'm great.
Call the list.
Item number 82, I'm mentioning upon notice. I'm praying for leave to file a supplementary paperwork.
Item number 82 of today's list. Non-commercial.
Commercial.
Non-commercial.
It's non-commercial. Well, no new papers. But
Pradut Kumar Shah.
Yes. In the original paper book that we have filed, my lord, 1 or 2 pages are missing of some documents which we relied on.
82 other side is here. No.
I'm mentioning upon notice. No new papers.
Mr. Bose, Learned Senior 82, Learned Senior Counsel representing the appellant says that inadvertently certain papers which were there before the learned single judge have not been included in the paper book that has been filed. Stop. He seeks leave to file a supplementary paper book incorporating such documents. Stop. Paragraph, such leave is granted. Let supplementary paper book be filed within?
By tomorrow.
By
the course of today also it can be done.
It's ready?
Yes.
We file in course of the week. In course of the week. In course of the week with a copy to a learned advocate for the respondent. Let the matter be stand adjourned and be listed again next week.
Grateful.
Next, huh? Next week.
I appear for the appellants.
We are here for the special officers, my lord.
Has come up on at their instance, my lord.
I appear for the purchaser.
And
Yes, you appear for the special officer.
we were,
Why has it been?
the special officers were directed to carry out a site inspection in Mumbai and file their report, my lord. So they had gone within 30 days, my lord, within 10 days of completing the inspection, my lord. The site inspection was carried out between the 21st and the 23rd, my lord. They were also present there on the 24th, but because it's a 21-acre land and it was raining very severely, it's a construction site with several multi-story towers that have been constructed. They were not able to complete it in its entirety.
You want some more time?
Rajab, I have something to say, my lord.
And my lord, there are certain other things that need to be brought before the court, my lord, that when the special officers were taking down the minutes, they were not allowed to take down the minutes using their own words. They were directed as to what should go into the minutes. They were not given entire free access. They were escorted everywhere.
Sir, we don't understand. Even if somebody wants to dictate, why will they be dictated?
No. And they were also restrained from inspecting the entire site area, my lord.
I am
By-
for the
by
purchaser,
the-
and I am taking an opposition to those submissions, my lords. Our representative was personally present, my lords, at the site. We have taken them across through the site, my lords. They were present and they have been shown the entire site. The minutes were prepared by them in the site office.
The minutes says that my
What is the
representative.
suit or we know nothing about the
Lordship,
matter,
Lordship,
Mr.
may I give a brief background?
No, no, no. To be mentioned what? You are not going to argue the matter today.
No.
Then my lord keeps it some.
Why? What do you want? Tell us.
My lord,
then.
what we want is, my lord, if the court directs us to carry out a further inspection to complete the entire inspection, that certain police protection must be given. And my lord, one more objection that was
My lord,
taken
I am
by the
opposing this,
purchasers was that the advocates for the appellant and the defendants who were present there were not allowed to be present while the site inspection was being carried on, my lord, because the order did not record that the joint special officer should be accompanied by the advocate for the parties.
Because may I
Lordship,
indicate this?
Lordship, I have
Minutes,
few-
may I indicate this, minutes?
My lord, and certain unparliamentary language was used with respect to the presence of the advocates for the plaintiffs and the defendants, my lord.
It will be listed under the heading appeal from orders at the top. Without hearing, without understanding what the matter is about, we are not going to pass any further order.
Very well.
We only had extended the time for implementation of the order that was passed by the coordinate bench. But now, without first apprising ourselves of the facts of the case, no further order, it will be listed as কিচ্ছু লিখতে হবে না কবে দেবে কালকে tomorrow itself will be listed.
Very well.
Item number 2 and 3.
Mediation এ পাঠিয়েছিলাম আমরা
Lordship, I appear.
Did I appear to the
Failed.
respondent? No,
I appear
still
for
in
the-
progress, my lord.
In-
The mediator has called upon parties to submit their final proposal, my lord. One more opportunity, perhaps.
Yes, yes. How much time should we?
Lordship, the next date is on 12th September, so the date be extended.
Shall we keep it towards the end of the term, just before the vacation?
Yes,
Yes, Lordship.
can you do that?
Original side, so 24th.
Lordship, and the time to file the report may also be extended.
We are told by learned advocates for the parties that the mediation is in progress. Stop. The next date is
12th September.
September 12, 2025. Stop. Paragraph list this matter once again. These matters correction. These matters once again on September
23, my lord, if possible.
24.
23rd, if possible, my lord.
No, this is appellate side day.
Oh, very well. Very well.
That is the difficulty. You won't be in court on 24th.
Perhaps not, but my lord, someone will appear.
Nothing will happen that day. Either we'll take the report
I understand.
under the same heading.
I'm deeply aware.
Investigation, item number 4.
Item number 4 is appearing at my instance. My lord, can you hear me? I am for the respondent. Am I audible?
Yes.
My lord, I am for the appeal.
My lord.
I am
My
withdrawing
lord, I
this
appear
appeal.
for the respondents in this matter, my lord, that this appeal is appearing at my instance, my lord. The suit wherefrom this appeal has been preferred by my learned friend, my lord, the suit has been withdrawn by us, my lord.
Oh.
For change circumstances. We have withdrawn the suit, my lord. The appeal has become infructuous, my lord.
Who are the appellants? The
I am
plaintiffs?
for the appellant.
No, the defendants are the appellant.
I see. Achha. The defendant, only one defendant, one
No, my lord.
respondent.
One respondent.
Mr. Mr. Dotto, there's only one respondent.
The one respondent. No. I appear for all the respondents.
The list indicates only one respondent.
One.
Respondent, my lord. Plaintiff is
One.
one.
Earlier there were two, one. No, it's one.
কিচ্ছু লাগবে না ও এটা ডিসমিসড হয়েই আছে
Yes.
ও
Restoration to pending actually.
তাহলে রেস্টোর করি
My lord, restoration application is pending, being GA2.
GA2 তে এটা অর্ডার করো this is an application for restoration of APOT 310 of 2024 which was dismissed for default on April 21, 2025 along with the connected application along with a connected application. Stop. Paragraph having heard, learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellants on the day the matter was dismissed for default. Paragraph accordingly, the order dated April 21, 2025, is recalled. Stop. APOT 310 of 2024 is restored to its original file and number along with GA1 of 2024. Next, GA2 of 2025 is disposed of. Next, এবারে APOT টা নাও heading to the APOT or GA1 টা নাও একসঙ্গে learned advocate for the respondent / plaintiff says that his client has withdrawn the suit. Stop. Hence, the appeal has become infructuous. Paragraph. The appeal being APOT such and such is accordingly disposed of along with the connected application.
Grateful, my lord. Grateful, my lord.
Connected application list nahi. Treating the same as on day's list.
Grateful, my lord.
Interim order, if any, stands vacated.
Grateful, my lord. I'm really grateful.
Item number 5 and 6.
I appear for the special officer.
My learned friend have carried out an application for substitution of the learned special officer because of his ill health. Your lordship had allowed me
that one, yes.
Yes, your lordship had allowed me to file an application. I filed an application stating that the company has come out of liquidation. I have annexed my annual account statements, the repayments.
No, does that mean that there is no requirement of a special officer now?
Lordship, that is my prayer.
Have you served the application?
Lordship, I have served.
Lord, we want to go out, Lord. We have no desire. Lord, we are holding 23 lakhs. Lord,
Whoever. You are for the special officer.
I'm for the special officer.
No, who's for the party?
Lordship, I appear in behalf of the company in liquidation. The OL, your lordship, had directed to file a report. Lordship, we have also served a copy.
And the appellants.
The
Appellants are not here also.
No, your lordship.
Your lordship, my lord, had directed my lord, the official liquidator, my lord, to file a comprehensive report with regard to the status of the company, my lord, by your lordship's order of 13th August.
Was that done?
Lordship, that has
We haven't got any, my lord. We haven't
no,
got
your
any.
lordship.
This is the first call. Shall we just come back in the second call?
Well, lordship.
If they come, or try to get them, the learned
We have
advocate.
served them, but we are not aware as to who is appearing, the advocate who is appearing on
Lord,
behalf of the
Mr.
owner.
Ronajit
Chaudhary.
Chaudhary was appearing, my lord. I'll
Normally he appears.
Yes, but I'll
Talk to him once and we'll come back.
Very well.
Pass it over.
Your lordship, before your lordship, 7 and 8, your lordship, item number 2 and 3, I couldn't come. I was on my legs before court 32. Your lordship, I am for the appellant in item number 3. Your lordship has given a date. Your
Yes,
lordship,
we've given a
kindly
date.
if your lordship could kindly record my appearance.
लेकिन ये नामटा नहीं है ना appearance to दिया और appearance तो नहीं है ना we item number 2 and 3 थे
Well, it's 7 and 8.
7 and 8, your lordship, praying for a short passover, your lordship.
Well, 7 and 8, my lord, the decree, my lord, was, my lord, finalized and has been sent to the collectorate, my lord, for the valuation that hasn't yet come.
oh
So,
this is that matter
yes, my lord.
that Mr. Shobhushaji Chaudhary
Yes, my lord.
well, then it will collectorate will take a little time
Mal.
so what 1 week 2 weeks 2 weeks
The 17th, let it come back. Malad,
Very
only
well.
one prayer, Malad, I was having, Malad, if your lordships may consider. Malad, since Malad, because of no fault of my client, Malad, this has delayed, Malad, the execution of the decree could not yet be filed, Malad, because of the decree was not being drawn up. So, Malad, I was only praying, Malad, if it, Malad, think it is right and proper, Malad, if the valuation can be of the date of the decree, Malad. And Malad. Because otherwise the market values now are very high.
The report become, your lordship.
There was also a finding in the earlier order, my
no,
lord,
it
that
is neither
it is, my lord,
it's not also the government's fault
my lord.
we say nothing on that if you can persuade them we say nothing on this we are told Lekho we are told that the decree in question has been sent to the collectorate
My lord.
for being
Valued, my lord,
valued for payment of stamp duty. Stop. Paragraph as suggested by learned advocates for the parties, comma, let this matter be listed again on September 17,
My lord.
comma, 2025.
Vishwakarma Puja chuti ache? My lord, one is Vishwakarma Puja, but I don't think, my lord,
No, there's no holiday. We have never had Vishwakarma holiday. Seven, 8 দুটো same order হবে আলাদা আলাদা করে
Item number 9.
Appearing at my instance, my lord, my
all right
yes, not better. Thank you. My lord, my appeal, there is also a delay. Well, the point is very short, but
affidavit of service
so that this was practically passed on consent. A suit for partition, preliminary decree, commissioner of partition appointed, report, no one files a exception, it's through. The decree says that the partition commissioner, he is going to go ahead and execute registered deeds of conveyance in favor of each party in respect of the respective shares. That is one bit of it that we've assailed. The other bit is a genuine problem that we're facing with regard to the Stamp Act, where each property now, each share is separated. Now, if it's a separated share, I'm entitled to actually pay stamp duty for only my share of. So, if that can just be clarified, the purport of the decree, the essential bit of it is just that.
is all very well. Where's your affidavit of service?
Sir, my brief is not traceable. Just now my
Pass over. We'll come back now.
Yes, yes.
Trace your brief.
Yes.
Presently, you are briefless.
This is my same problem in the car.
Oh, get your briefs.
Yes, ma'am.
Item number 10.
Lordship, item number 10, I am for the appellant, my lord. There is a request made by the respondent lawyer, my lord. He has some personal difficulty, so he has requested to keep it next Wednesday, my lord.
Next Wednesday. Very well. Learned advocate for the appellant says that he has been requested by learned advocate for the respondents not to do the matter today as he is in difficulty. Stop. Paragraph as suggested, comma. Let this matter be listed again on Kobe.
I'm grateful, my lord. May I hand over the letter, my lord?
Do the letter. নিয়ে নাও, রেখে দাও সঙ্গে, কিছু করতে।
I'm grateful.
Number 11. I appeal, my lord.
11, my lord, I appear for the respondent. And he was successful before the learned court below.
My lord, order is, my lord, for impleadment of a party, my lord, in a suit which was proceeding ex parte. My lord, I am for the plaintiffs. We oppose the impleadment, my lord, on the ground that the party was seeking to be impleaded on the basis that he is the descendant of one of the alienees of one of the suit properties concerned. We were opposing this, my lord, on the ground that the descendants of that alienee had already been impleaded in the suit as party defendants. Thereafter, my lord,
Allow us to go through the orders, sir.
My lord,
Take
one
your seat.
point as to maintainability also, my lord, we'll take. My lord, this is an order, my lord, in only adding me as party. Order 1, Rule 10. It's not really a final judgment within the meaning of clause 13, my lord.
Yes, but Mr. Mukhopadhyay,
15, yes.
He's the plaintiff. He has carriage of proceedings.
But here, this is the only difference. This is a partition suit. This is the point we'll try to urge.
Oh,
It's
this
a
is a
partition
partition
suit where, my lord, every defendant, my lord, knows it's an my lord, it's effectively every defendant can
Who
be
is
a
Mr. Chaudhary for?
Lord, I was told to file a notice of argument. I did so. Then, Lord, on the next day when I went, I was 2 minutes late. I was told no arguments, order has been pronounced or will be pronounced. And if I could have argued, I would have been able to persuade the learned judge, and so is my belief. I want to go back to the same learned judge and get a chance to argue, because this, according to me, is misconceived. Alienee,
What is misconceived?
Milord, addition of Milord a person in a partition suit. Alienee of a property alleged to be, Milord, a joint family property in the plaint filed by me, wanted to, Milord, be added as a party. During the pendency,
Purchaser.
Purchaser. Milord, during pendency, he, Milord, dies, matters closed.
Who dies during
Milord,
pendency?
the purchaser
Dies.
Now, Milord, his descendants, Milord, or persons who I say are not his descendants, they, Milord, come and file an fresh application for being added as a party. We may not dispute that position.
Purchaser was a party.
Purchaser wasn't a party.
Wasn't a
Purchaser
party.
wanted to be added.
I see.
I'm sorry, Milord. Purchaser's descendants were added. Milord, their descendants wanted to, Milord, come in. And, Milord, we said that your earlier application was dismissed. Milord, my mistake, Milord. That's the reason. Milord, person who wanted to, Milord, be brought in are descendants of a purchaser.
All owners of a property,
Yes.
which is sought to be partitioned,
Yes.
should be parties to the
Should be parties.
partition suit.
Yes.
Purchaser owned some share in the property.
Yes.
So he was not a party. He must have been a party.
His descendants are already added.
His descendants are there.
Somebody else who wants to, who claims to be his descendants, which we dispute, Milord, wants to be added. Point, Milord, is the first application was dismissed for non-prosecution because of death. You have to go get that, Milord, restored, and, Milord, substitute yourself there and prosecute that petition. You can't file a fresh petition. It's barred by Order 9, Rule 9. This is the point I wanted to argue. And it's, Milord, the plaintiffs. Point number 1, Milord, plaintiff's prerogative. Whom to be added as a party, whom not. Plaintiff chooses. If my
It's a
suit
partition suit, everybody is in the position of a plaintiff.
And then, the other questions of fact. Now, Milord, this is the situation. If your lordship, Milord, feels I'll argue it before your lordship, I have no difficulty.
So let us at least see the order.
Yes.
We have not yet seen the order.
Page 436.
Sir, may I place the order, my lord?
We'll read it. We'll read it. You take your seat. We'll read it.
Notes of argument कौन पता है आज?
What is your client's name, Mr. Sengupta?
Mr. Priyobrata Chakraborty, Your Lordship.
Priyobrata Chakraborty
Yes, sir. He is, Your Lordship, the executor in a will of the deceased.
of
So I took
Shantundo.
a point, Your Lordship, section 211 of the Indian Succession Act that during the pendency of the probate, Your Lordship, the executor will represent the estate. Yes.
Property was transferred to him. চুপ করো।
When the application that was filed by Shamsundar Sarauji was dismissed for default,
Yes, I was present.
You were present. Yes. The order will show that.
Yes, Honorable. Lord, I just want your lordship to see one page, 430 capital A. Just one page, which is my notes of argument. Please, my lord, see 430 capital A from the end of 430 capital B.
Mr. Chaudhuri, you know better than us. We can't travel beyond the order. If you say learned judge has not done this, not done that, not recorded this, we can't say that. Go for review. Go for review.
63, my lord, is the dismissal order.
Why are you showing 430A? Why?
430A, my lord, for your lordships to come to 430B at the bottom.
Yes.
The present application is not maintainable. Order 9, Rule 9 travels, my lord, to the next page with the judgments. Now, I want your lordships to see page 63, which is the order of dismissal of the first application, which records my learned friend's name.
So this point has not been
considered.
So he point if you
If your lordships decided 63.
And the proper course of action would be
6-3.
there is a order line. Okay, restoration is going to substitution. Restoration.
Shamsundar. And Shamsundar was claiming to
Mr.
be
Shengutto,
Sir,
we have this in mind. Good, bad, indifferent, they have taken a point of maintainability of your application. That has been noted by the learned judge towards the beginning of the order, that their submission that the proper course of action would be this, but not discussed thereafter. On that sole ground, we want to remand it, leaving all points open. Take instruction. We will not express prima facie, it seems. Order 9, rule 9 may be a problem for you. But we will not decide that. We will not
One thing,
decide.
Your Lordship, when this particular page 63, when this order was passed at that point of time, Your Lordship, Mr. Sarogi was no more. Now the thing is, problem is, Your Lordship, he is an executor who has filed this application. Lordship, if he has to file an application, Your Lordship, it has to
Not
be.
on that, a point has not been decided. That is the only ground. A point, although noted by the learned judge, has not been decided. We are not addressing anything else. Go back, fight it out.
Only for the limited purpose,
No,
Your
no,
Lordship.
no.
Otherwise,
No, no, I'll
I carry
argue.
to you, Your Lordship,
I'll-
will be
I'll-
open. It's your
I
inspector,
didn't
Your
get a
Lordship, will
chance to
Lordship
argue.
take up
What
the
do you
matter.
mean
Your
by
Lordship.
limited purpose? No, no, not limited purpose.
Then the entire, because Your Lordship, in the partition suit, Your Lordship, these particular persons are Your Lordship proper and necessary parties. Who am I? I am only an executor in connection with the estate of that particular person.
Mr. Shengupta, we'll just say this point was urged, recorded, not decided, solely on that ground. We are saying nothing more.
Understand?
The other points we are not setting aside.
But
In the sense, on merits we are not considering.
the reason, Your Lordship,
On
with
merits-
deepest respect, Your Lordship, is this particular point, Your Lordship, is
Nothing will stop the learned judge from passing the same order if the learned judge rejects their point of maintainability.
But I understand, but Your Lordship, if this is a legal point, I can understand, Your Lordship, we should go back before the Honorable Single Judge.
Yes.
But if Your Lordship kindly sees his point, Your Lordship, which he has taken before the Honorable Single Judge, that's not a point at all, Your Lordship, as per the law. Because the reason is, if Your Lordship kindly sees page 63, that particular date when this particular order was passed, that person, Your Lordship, is no more. Their contention is, I should have filed a substitution application before Your Lordship filing a fresh application. That's the only ground, Your Lordship, Mr. Chaudhary has taken. In this case, Your Lordship, I just may make one humble submission that apart from that, taking that avenue, I have filed a separate application for Your Lordship implement. That's the exactly thing, Your Lordship, I have done. If it is, Your Lordship, not permissible in law, then Your Lordship remand it back. Otherwise, Your Lordship, kindly hear it. The reason, Your Lordship, is there is no point, Your Lordship, again sending me back, Your Lordship, because this particular application is not a maintained. With GPS respect, there is no bar in the filing of that particular application. How can I file a substitution application in, Your Lordship, in an application for intervention?
What was Shamsundar's application? Also for implement?
For intervention. He wanted to intervene. Here, Your Lordship, I am saying, Your Lordship, he is a proper and necessary party in a partition suit where he has some interest.
Where is that application?
And section 200, Lordship,
Again,
kindly
you are
take-
dragging us into the
Milord,
nitty
may I
gritty.
just say this? Milord, I am also, Milord, if your lordships decide the whole matter, I don't mind. It will be
Appeal
a
court, if
decision.
appeal court takes everything upon itself to decide, it will become very difficult.
Also now, Milord, I would just want once.
Go back, Mr. Shengupta, go back. We'll couch our order in such a manner that in the event their point of maintainability is rejected by the learned judge will be at liberty to pass the same order.
But we'll
Kindly
also have the liberty to, Milord, urge the learned judge, urge, Milord, that the learned judge should not
Liberty.
pass that order.
Everybody will have all liberties, including the learned judge.
Naturally. No, I have no, my lord, to be very fair to the honorable judge,
Sure.
my lord, I have no difficulty going back.
This appeal is directed against a judgment and order dated July 16, 2025, whereby an application for impleadment as defendant in the suit filed by the appellants in a suit filed by the appellants কি বললাম? No, it has been, this appeal is directed against application. Your client is Dilip Kumar Modi.
No. Priyavrata Chakraborty. Page 22, your lordship, is my application.
He is respondent number what in this appeal?
No, they have not implemented me as a respondent. Here I am not a respondent. They have not implemented me. They have only served me.
I've served, paid for liberty to serve. I'm saying that he should not come into the cause title at all.
I have been already
and I've served him
as a
before coming and moving.
And necessary correction has already been done.
My lord, I have to follow the cause title. Original side, not I have to follow the cause title.
Application. The bill is directed against us. Filed by one in which the application for impleadment as defendant filed by one Priyavrata Chakraborty in CS number 136 of 2010, being a suit filed by the appellants herein, has been allowed by the learned single judge. Sri Priyavrata Chakraborty has been directed to be added as a defendant in the suit. Being aggrieved, the plaintiffs are before us. Paragraph. The learned senior counsel representing the appellants oblique plaintiffs says that the application filed by Priyavrata Chakraborty, Priyavrata was not maintainable. This is because a similar application filed by his predecessor in interest was dismissed for default. The proper course of action for Priyavrata would have been to have that application restored and to proceed with the same. Paragraph. We see from the order impugned that such point of maintainability has been noted by the learned single judge. State. আচ্ছা কি বললাম but has not been decided. Paragraph. Hence, without touching the merits of Priyavrata's application, we remand the matter to the learned single judge for deciding Priyavrata's application afresh in accordance with law. ও আচ্ছা না we find বলেছি যে ওখানে বলেছি না we find that আগে প্যারাগ্রাফটা বল আগে প্যারাগ্রাফ হ্যাঁ ঠিক আছে রিমান্ড ফর কি বললাম Stop, all points are left open. Stop. We request the learned judge to decide the point of maintainability first. Paragraph disposed of. Appeal and application.
I may have permit to submit the notice of motion.
Sorry, what?
The notice of motion.
No notice of motion.
That's the now. I'm grateful, madam.
Without being influenced. Only one line may be added, Your Lordship, that the Honorable Division Bench has not gone into the merits of the
Yes, without touching the merits, we have said.
There in the
We have said so.
I'm grateful.
Number 12.
But I appear for the appellant, my lord. But I'm led by Mr. Moinak Bose in the matter, my lord. He's not in court today, my lord. I was praying for a not today if that beseeches your lordships. Any other?
On the request made by learned advocate for the appellant, let this matter stand adjourned for the day. New application second call.
Item number 5 and 6.
My lord, I am for the official extremely sorry, my lord.
No, that's all right. Have you filed that detailed report?
Yes, my lord, I have got the reports.
What is the status? Somebody said that Mr. Varun Kothari.
Yes, my lord, one of the companies, my lord, if your lordships kindly see, that is, my lord, if your lordships kindly see page 4, paragraph 4 and paragraph 5.
Empire Jute Company Limited.
Yes, my lord. They are, my lord, they are another, my lord, Lumtex Engineering Private Limited. They are occupying the, my lord, the area, and my lord, they have made several applications.
Now the other side, your other side is not here. We'll take this on record and we'll keep it next Monday.
Very well, I'm deeply blessed.
Report filed by the official liquidator in terms of our earlier order be kept with the records. Paragraph. Since on this second call, learned advocates for the other parties are not present, let this matter be listed again on Monday.
I'm deeply blessed.
Second call, item number 9.
I am for the appeal in your lordship. Mr. Banerjee was leading me, your lordship. This is an appeal arising out of an order passed in a partition suit, your lordship.
Service?
Your lordship, my original brief has just been misplaced. Somebody has taken from the, but on the last occasion, Mr. Cord.
I appear for some of the respondents.
I have served everybody, your lordship. Mr. Cord is also on the last occasion. His junior was present, your lordship.
Very well. You moved this.
There is a section 5 application. There is a delay of 277 days, your lordship.
Proposing.
Yes, allowed. Ay, what number item? 9. GA1. GA1 lekho. This is an application. Then when will you file the affidavit of service? You have to affirm a fresh one.
I have to affirm a fresh one.
By tomorrow, can you file?
I have to serve because the original, I can give a copy of the letter because the original letter was with the original affidavit of service. 2 copies were there. Now the entire brief is not.
No, the copy of the letter will show service on all the respondents.
Yes, that was attached with the affidavit of service. Original as well as the Xerox copy was also in the brief. The entire brief is misplaced. In the morning, it was kept outside the table. Somebody might have wrongfully taken with the other brief and carried out with it. No.
You have a copy of the letter.
everything was in the brief. This is the whole difficulty I'm facing.
You appear for which respondents?
Lordship 6 and 8.
6 and 8. Bakida?
Mr. Joydev Ghorai, I have served. He is appearing for the, he was the plaintiff.
Somebody's coming. Somebody's coming.
On the last location.
Lordship, we are all for the same respondents.
Tarar kila bolo.
Lordship, it's a
What
very
to do? You have to show us service, sir. Otherwise, it won't be proper.
Lordship, then I have to again serve them and intimate that the matter was taken up and you are.
The respondents who are not represented, then serve them again.
Lordship, I'm sorry, we are for respondent numbers 14 and 15.
Learned advocate for the appellant says that although service has been effected on all the respondents, comma, he cannot demonstrate the same since his entire brief has been misplaced, which contained the affidavit of service. Stop. Paragraph. The respondent numbers 14 and 15 are represented. 14 and 15?
14 and 15, madam.
Represented to learned counsel. Appearance done now. Stop. Let fresh service be effected on the non-appearing respondents and affidavit of service be filed on the next date. When?
Your Lordship, you keep it this week, Your Lordship. I can serve it anytime on Friday, but Your Lordship takes up to.
No, Friday you come, we'll take it up.
Oh, Friday is holiday. Then
Monday,
next Wednesday, because
next Wednesday.
is a
Very
commercial day.
Paragraph, list the matter once again on next Wednesday.
So it's a very short point. Only the point of whether a deed recording partition needs to be stamped and registered. The decree passed, the final decree passed actually says execution of a deed. Short point.
What is your contention?
If our contention is if a deed is to be executed, it has to be stamped and registered. If it was by way of a decree, then we have to only stamp it. We don't need to register it. Short point.
Come back, come back. Come back with the case laws.
Not appeal. Item number 30.
Normal paper book গুলো কি দিয়ে দেবো? হ্যাঁ দেবাক মিলবে তো? হ্যাঁ একই কথা।
Allow us to keep this next week because we wanted to go through the evidence and come back.
I can take my note through the evidence. It will not take long.
No, that will hold up the court. That will hold up the court. We'll come ready. This time we'll come ready and it won't take much time then.
Very well. My
You
lord,
tell us when you will be available.
my lord suggests a date. I'll just.
Next Wednesday.
10th. My lord, could it be some next Wednesday? I might be in some difficulty.
It might be difficulty. Very well. It can be on Monday, but
No, not Monday. I will not be in town. Be in Ranchi.
non-commercial matters we take up only on Wednesdays. Then 17th.
My lord keeps it on the 17th.
17th.
My lord, may I file two unofficial paper books? My lord, all papers were included with the stay application. However, there are, I have also put in the advertisement, the special citation, the paper publication, that's all included there.
Informal paper books filed by the appellant.
And all orders passed by the trial court.
Appellants. Which includes informal paper book, which includes all papers that were available before the learned single judge and single judge be kept with the records. Paragraph, list this matter under the same, list this matter once again on 17 under the same heading, retaining its position. Hey, aaj ki patao. Easy.
It's a fixed matter. Item number 14.
Yes.
Mr. Ghoshal is out of India. So he has requested Mr. Ghosh to do it next week.
Oh, very well.
Next Wednesday.
As jointly prayed on behalf of the parties, comma, let this matter stand adjourned and be listed again on 10 tarikhe.
May it please your lordship.
My lord, I am appearing on behalf of the respondent.
You are there for the respondent?
Yes, my lord, I am for the plaintiff one.
May it please your lordship. My lord, I was on the last occasion I was addressing.
Okay. Correct, correct. Correct.
Because it will be decided first.
Correct. One who has approached court. Absolutely. Yes, Mr. Chatterjee.
Yes. It may come back to your lordship's mind, Miller. The issue
The point is filing of written statement, extension of time.
yes, in respect of a suit filed before the coming into force, or rather the enactment of the Commercial Courts Act, which stands transferred to the Commercial Division by virtue of Section 15. Section 15, subsection 1 in this case. And the impact of Section 15, subsection 4 in the matter of filing of a written statement in such suit, when written statement has not been filed before the transfer. The issue is, Miller, whether after the transfer to the Commercial Division, the transferee court exercising jurisdiction under the Commercial Courts Act in the course of case management is obliged to allow a further opportunity to the defendant to file a written statement in view of the language of section 15 subsection 4 provides so. My lord, I had handed up to your lordships.
Are you really saying it's an obligation? It's mandatory?
Yes. For my first case, it is mandatory. My second case is that even if it is discretionary, in our case, in the impugned order, the learned judge has not adverted to that also. That discretion has to be exercised, and the exercise of discretion must appear in the order. If your lordships are with me, ultimately perhaps the matter has to go back to the learned judge exercising commercial division to consider this question. But your lordships have to lay down that, Millard, the learned judge, I say, was under an obligation, but even if not so, I am entitled to a consideration of my prayer, and the learned judge is obliged to apply his mind, his or her mind, to whether a written statement, I should be given an opportunity to file a written statement.
Mr. Chatterjee, before we proceed further, as is our practice, we'll just want to go through the impugned order once.
Yes, yes.
And we'll read it. You please take your seat.
Very good.
We'll just read the impugned order once. Yes, Mr. Chatterjee.
I would submit that, in fact, exercising non-commercial jurisdiction, the learned judge had no opportunity also to consider section 15.4. But really, it should have been considered in the commercial division, and the impact of 15.4 ought to have been adverted to. Well, I had, on the last occasion, I had handed up to your lordships a compilation of the relevant provisions.
Yes.
I will just place section 15.4 once and move over to the cases which have construed this provision. Yeah, yeah. On page 2 of the tabulation, subsection 4 is quoted. First of all, section 15, subsection 1 is all suits and applications, including applications under the Arbitration and Conciliation Act 1996 relating to a commercial dispute of a specified value pending in a high court where a commercial division has been constituted shall be transferred to the commercial division. Now, kindly see subsection 3 over the page, where any suit or application, including an application under the Arbitration and Conciliation Act 1996 relating to a commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures that were not complete at the time of transfer. Then subsection 4, the commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may be necessary for a speedy and efficacious disposal of such suit or application in accordance with Order 15A of the Code of Civil Procedure 1908. Then, the proviso is important, provided that the proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure 1908 shall not apply to such transferred suit or application, and the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. Now, Miller, these words have been judicially construed by different high courts, and I shall now place those judgments. Starting with, Miller, the most with the judgment which has gone into detail while considering this aspect. This is the judgment of a division bench of the Andhra Pradesh High Court, reported at 2022 SCC Online AP 136. SCC Online AP 1. Well, paragraph 5, briefly for the facts, briefly stated the facts of the case as submitted by the learned counsel for the petitioner are that the plaintiff respondent filed original suit number 11 of 2018 for recovery of money against the petitioner defendant with subsequent interest at the rate of 12% per annum till the date of realization for costs of the suit and for such other relief or reliefs as the court deems fit and proper in the circumstances of the case. The petitioner defendant did not file his written statement in the suit within the stipulated period. Later on 7th of December 2018, the petitioner filed a petition under Section 148, read with Section 151 of the Code of Civil Procedure Code, that is IA number such and such, before the Principal District Court, Visakhapatnam, seeking extension of time for 15 days for filing the written statement, pending IA number such and such. On 2nd January 2019, the petitioner filed the written statement. During the pendency of IA number such and such, in view of the establishment of the commercial code, original suit number such and such was transferred to the Court of Special Court for trial and disposal of commercial disputes, Visakhapatnam. Before the special court, the petition filed by the petitioner defendant, that is IA number such and such, under Section 148, was dismissed for default, against which the petitioner filed IA number 32 of 2020 under Order 9 Rule 9, read with Section 151 for restoration of IA number such and such, was filed beyond the period of limitation. The petitioner also filed IA under Section 5 to condone the delay of 183 days. The learned special court below, by order dated such and such, dismissed IA such and such, against which the present petition has been filed. Now, Miller, kindly come to, very well, let me place this. Sri Vedula Venkatraman, learned senior advocate, submitted that the suit was initially instituted in the civil court, from where it was transferred to the commercial court under the Commercial Courts Commercial Division and Commercial Appellate Division of High Courts Act 2015. He submitted that as at the time of transfer of the suit, the petitioner's application for extension of time under Section 148, read with Section 151 CPC, was pending in view of the procedure applicable to the regular suits, under which the regular court has the power to extend the time beyond the statutory period of 90 days. The commercial court would also have the power to extend the period of 120 days suitably for filing the written statement. He submitted that although on transfer, the commercial court was not required to issue fresh summons, where summons had already been issued by the regular court. But in such a case, the period of 120 days for filing the written statement would be from the date of transfer of the case to the commercial court. He submitted that as on the date the suit was transferred to the commercial court, the written statement had already been filed before the regular court with a delay of 29 days. Pending IA number such and such, the same could be taken on record. Placing reliance on the judgment of the Honorable Supreme Court in Salem, he further submitted that the period of 120 days for filing written statement before commercial court could be extended, taking the provision as directory and in the interest of justice. Now, will let kindly come to paragraph 10. Sri Ravi Kumar, learned counsel for the respondent, submitted that in its application to the commercial disputes before the special courts, the provisions of CPC as amended in the manner specified in the schedule under section 16 of the Act of 2015 shall only apply as per section 15(3). And as per the amended provision, the special court has no power to accept the written statement beyond the statutory period of 120 days, which period cannot be extended in view of Order 8, Rules 1 and 10 CPC. And on expiry of such period, the right to file written statement is forfeited. He further submitted that that on the date of transfer of the suit to the special court, the period of 120 days had already expired. The special court had no power to extend the time as section 148 CPC does not apply to the commercial courts, and particularly in view of Order 8, Rules 1 and 10, he has placed reliance on SCG contracts. Then Millard, paragraph 12. On our specific queries, Ravi Kumar has fairly not disputed that the very basis of rejection is the view taken by the court below that the commercial court has no jurisdiction to extend the period of filing written statement beyond 120 days from the date of service of summons. A perusal of the impugned judgment clearly shows that the learned court below, while rejecting the petitioner's applications, observed that even assuming for the argument's sake that the petition filed by the petitioner under Section 5 of the Limitation Act for condoning the delay was to be allowed, the court below shall have no power to receive the written statement filed by the petitioner after expiry of the statutory period of 120 days. And on such expiry, the right to file written statement is forfeited. And hence it was not inclined to accept IA number 31 of 2020, which was accordingly dismissed. In taking the aforesaid view, the court below took into consideration the provisions of Order 5, Rule 1, Sub-Rule 1, Second Proviso, Order 8, Rules 1 and 10 CPC, and the judgment of the Honorable Apex Court in SCG contracts. Now, Millard, paragraph 15. The following points arise for our consideration. This is, Millard, the High Court is going into the questions of law. The following points arise for our consideration and determination. Whether in a suit transferred to the commercial court from the regular civil court under section 15(2) of the Act of 2015, in our case, Millard, it's section 15(1) because it is High Court to High Court. The commercial court has the jurisdiction to extend the period of 120 days or grant a fresh period beyond 120 days from the date of service of summons on the defendant for filing the written statement, whether the rejection of IA number such and such by the commercial court is justified. To consider the aforesaid point for determination, it is apt to refer to the following provisions. Well, I need not trouble your lordships with this provision, which your lordships have already perused, section 15. Kindly come to paragraph 18. That also is in that chart, but section 16 of the Act 2015 provides as under amendments to the Civil Procedure Code 1908 in its application to commercial. The provisions of the Civil Procedure Code shall in their application to any value, to any suit in respect of a commercial dispute of a specified value stand amended in the manner as specified in the schedule. The commercial division and commercial court shall follow the provisions of the Civil Procedure Code as amended by this Act in the trial of a suit in respect of a commercial dispute of a specified value. Where any provision of any rule of the jurisdictional High Court or any amendment, your lordships need not, I'll not trouble your lordships with this because this has no application. Paragraph 19. A bare reading of section 15(2) of the Act of 2015 shows that all suits and applications, including applications under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of a specified value, pending in any civil court in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court, with the exception that if final judgment has been reserved, such case shall not be transferred. As per subsection 3 of section 15, to those cases, that is the cases which shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2 of section 15, the provisions of the Act of 2015 shall apply to those procedures that were not complete at the time of transfer. Section 15(3) therefore provides for the applicability of the provisions of the Act of 2015 to a case transferred to the commercial court to those procedures that were not complete at the time of transfer. Section 16 of the Act, your lordships have already seen that. This is only paraphrasing. Then paragraph 22. In view of the aforesaid provisions of section 15(3), that the provisions of the Act of 2015 shall apply to those procedures that were not complete at the time of transfer. The stage of the present suit at the time of its transfer to the commercial court requires consideration. It is undisputed that at the time of transfer, the petitioner's application for enlargement of time to file written statement under section 148, read with such and such, was pending before the regular civil court, same as our case. The provisions of Order 8, Rule 1 CPC, applicable to such regular civil court, as per the law declared by the Honorable the Apex Court in the case of Salem Advocate Bar Association, are part of procedural law and are directed. A prayer for extension of time to file written statement may be allowed beyond the statutory period by way of exception, though not frequently or in a routine manner. We are not applying Salem Advocate Bar Association to the present case, but we have referred this case to point out that before the regular civil court, the suit was at the stage of the written statement, if it was to be accepted or not, and there was no statutory bar in its acceptance, subject, of course, on the principles as laid down in Salem Advocate. There was also no forfeiture of the right of the petitioner to file written statement after the statutory period of 90 days as applicable before the regular civil court. To put it differently, at the time of transfer of the suit to the commercial court, the procedure as regards filing of the written statement had not been completed. If the petitioner's application for extension of time to file written statement had been rejected by the regular civil court or by statutory provision on expiry of statutory period, the right to file written statement had already been forfeited before the regular civil court itself. The position might have been different. In our case also, Millard, the application was pending before the regular civil court at the time of transfer, and the rejection took place after the transfer in purported exercise of jurisdiction as a regular civil. Now, Millard, paragraph 24. Now we proceed to consider the applicability of the provisions of the Code of Civil Procedure as amended. Now, Millard, your lordships may skip this part. Kindly come to para 27, because before that it is all quoted. According to Order 5, Rule 11 CPC, the defendant has to file the written statement within the period of 30 days from the date of service of summons on such defendant. And if he fails to file written statement within such period, he shall be allowed to file the written statement on such other day as may be specified by the court, which shall not be later than 120 days from the date of service of summons. And on expiry of said 120 days, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. Order 8, Rule 1 CPC also provides the same, and the proviso to Rule 10 of Order 8 states that no court shall make an order to extend the time provided under Rule 1 of Order 8 for filing the written statement. In SCG Contracts India Private Limited, the Honorable Supreme Court, this was, Millard, Millard, I wish to make it clear that this was, the Supreme Court decision was a case in which the original suit was filed in the commercial division after the act. And that on that ground, it has been distinguished also later. On consideration of the provisions of Order 5, Rule 1, Order 8, etc., held that a written statement is to be filed within a period of 30 days. However, grace period of further 90 days is granted, which the court may employ for reasons to be recorded in writing, and on payment of such costs as it deems fit to allow such written statement to come on record. Beyond 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. It further held that the court has no further power to extend the time beyond this period of 120 days. In view of the consequence of forfeiting the right to file the written statement, non-extension of any further time, and the fact that the court shall not allow the written statement to be taken on record, as provided by the provisions of Order 5, Rule 1, Order 8, Rules such and such, it was held that earlier law on Order 8, Rule 1 CPC on the filing of the written statement under Order 8, Rule 1 has now been set at naught. Namely, Millard, Salem Advocate, that directory part will not apply, and now the amended provisions of the code as amended by the Commercial Courts Act, which says that after expiry of a certain period, the right to file written statement shall stand forfeited, shall apply. Now, Millard, kindly skip the next paragraph because they quote from SCG Contracts, and kindly come to paragraph 12, after referring to SCG contracts and a few more judgments of the Supreme Court, this is what the division bench says. The judgment of Okutech relied upon the learned single judge is no doubt good law, as recently upheld by this court in SCG contracts. But its ratio concerning the mandatory nature of the timeline prescribed for filing of written statement and the lack of discretion with courts to condone any delay is applicable only to commercial disputes, as the judgment was undoubtedly rendered in the context of a commercial dispute qua the amended Order 8 Rule 1 CPC. As regards the timeline for filing of written statement in a non-commercial dispute, the observations of this court in a catena of decisions, most recently in Atcom Technologies, holds the field. Unamended Order 8 Rule 1 continues to be directed. Now, Millard, paragraph 33. But here we are concerned, Millard. This is, Millard, I am strongly relying on this. But here we are concerned with a case where the suit originally instituted in the civil court was transferred to the commercial court under section 15 subsection 2 of the Act of 2015. What we find is that SCG contracts is not a case in which the suit was transferred to the commercial court from the regular civil court. 34. With respect to a case which is transferred to the commercial division or commercial court from the High Court or civil court, as case may be under section 15.1, which is our case, or section 15.2 of the Act of 2015 respectively, subsection 4 of section 15 provides that the commercial division or commercial court, as the case may be, may hold case management hearing in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may be necessary for a speedy and efficacious disposal of such suit or application in accordance with Order 14A of the CPC. The proviso to Subrule 4 then provides that the proviso to Subrule 1 of Rule 1 of Order 5 CPC shall not apply to such transferred suit or application, and the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. The provision of section 15.4 of the Act of 2015 was not under consideration in SCG Contract India Private Limited, which fortifies that that was not a case of a suit transferred to the commercial court from the civil court of its institution. Now, Millard, paragraph 37. The applicability of proviso to Subrule 1 of Rule 1 of Order 5 CPC has been expressly excluded to the suits or applications transferred to the commercial court, and the commercial court has been vested with the discretion to prescribe a new time period within which the written statement shall be filed. When both the provisions, that is the proviso to Subrule 1 of Rule 1 of Order 5 and the proviso to section 15.4 of the Act of 2015 are read together, the apparent conclusion is that on expiry of 120 days from the date of service of summons, if written statement is not filed, the right to file written statement cannot be forfeited because of the non-applicability of second proviso to Order 5, Rule 1, Subrule 1, to a suit transferred to the commercial court under section 15.1 or 15.2. And the time limit of 120 days specified in second proviso to Subrule 1 of Rule 1 of Order 5 CPC also loses significance, firstly, because of its non-applicability, and secondly, because section 15.4 itself provides that the commercial court in such a transferred case may in its discretion provide a new time period for filing written statement within which the written statement shall be filed. Here we notice an anomaly in the statutory provisions. A comparative study of the second proviso to Order 5, Rule 1, Subrule 1 CPC and the proviso to Order 8, Rule 1 CPC as amended through Section 16 of the Act of 2015 shows that both the provisions are verbatim the same. Section 15, subsection 4 of the Act of 2015, which expressly excludes the applicability of the proviso to Subrule 1 of Rule 1 of Order 5 CPC, is silent about the proviso to rules 1 and 10 of Order 8. On the one hand, proviso to sub-rule 1 of Rule 1 of Order 5 CPC shall not apply, meaning thereby that with respect to the suits or applications transferred to the commercial court from the civil court under section 15, 1 or 2, the right of the defendant to file written statement shall not be forfeited, even if the same is not filed within a period of 120 days from the date of service of summons. And further, in view of section 15.4 itself, the commercial court may in its discretion prescribe a new time period within which the written statement shall be filed. But on the other hand, in view of the proviso to Order 8, Rule 1 CPC, on expiry of 120 days, the right of the defendant to file the written statement, if the written statement is not filed within that time limit, shall be forfeited. And the court shall not allow the written statement to be taken on record on expiry of such period, nor the court shall extend the time for filing the written statement in view of Rule 10 of Order 8 CPC. Both the provisions, that is section 15 subsection 4 proviso and Order 8 rules 1 and 10, therefore, apparently cannot be given effect to at the same time. This anomaly is to be resolved, and for that we advert to the principles of interpretation of statutes. Now, I will not trouble your lordships with all this, because your lordships are well aware, very well settled principles, that where there is a general provision and the special provision, the general must be construed as excluding the special provision, and the special provision will operate. The division bench has referred to a number of authorities on this position and then come to a conclusion. Kindly, Millard, come to paragraph 51. After considering all authorities on the rules for interpretation of statutes, the division bench comes to the conclusion, after noting the apparent anomaly, it is thus well settled that a statute must be construed according to the intention of the legislature. It is the duty of the courts to act upon the true intention of the legislature, and it is the words used which best disclose such intention. The first and primary rule of construction is that the intention of the legislature must be found in the words used by the legislature itself. It is also well settled that the basic rule of interpretation is the plain meaning rule, which suggests that when the language in the statute is plain and unambiguous, the court has to read and understand the plain language as such. Any hardship and inconvenience cannot be the basis to alter the meaning to the language employed by the legislation. But if the plain language results in absurdity or anomaly, the court is entitled to determine the meaning of the word in the context in which it is used, keeping in view the legislative purpose, and can even explain the intention of the legislation. Well, I'll skip over paragraph 53 because it is also, it discusses the rules of construction. Then paragraph 54. Keeping in view, sorry. why it's so appended therein. The next limb of argument of learned counsel for the petitioner is that curiously, in the judgment of Supreme Court, in SCG contracts, the apex court did not deal with subsection 4 of section 15 and its proviso, and therefore the said judgment is not a hurdle for the petitioner. Now kindly come, Miller, to paragraph 11, after the learned judge quotes the provisions, and then paragraph 11. The language employed in subsection 4 aforesaid makes it crystal clear that after transfer of matter to the commercial court, the case management hearing needs to be applied. And for that purpose, next words I'm strongly relying upon, the court is obliged to prescribe a new timeline or issue further directions. The language of the statute is plain, simple, and unambiguous. Thus, it must be given effect to, irrespective of its consequences. A plain reading of judgment of the Supreme Court in SCG contracts makes it clear that the apex court has not considered subsection 4 of section 15 of the Act of 2015 in specific. During the course of hearing, learned counsel for both the parties fairly submitted that in the case of SCG contracts, the suit was directly filed before the commercial court, and therefore there was no occasion for the Supreme Court to deal with subsection 4 of section 15 of the Act of 2015. And this is trite that a singular different fact may change the precedential value of a judgment. Since in SCG contracts case, suit was directly filed before the commercial court, and apex court did not deal with section 15 subsection 4 of the Act of 2015, the said judgment is of no assistance to the respondent. The division bench in the case of Amoda Iron Steel Limited, that is the Andhra Pradesh division bench, considered the above judgment of the Supreme Court in SCG contracts and enabling statutory provisions, including section 15 subsection 4 of the Act of 2015, as well as Order 5, Rule 1, and Order 8, Rule 1, and Rule 10 of the Code of Civil Procedure. It is apt to consider few paragraphs of this judgment. Then, Miller, I am not troubling your lordships because this is quoted from the Andhra Pradesh judgment, which your lordships have already seen. Then, Miller, in paragraph 15, the division bench again quotes paragraph 61, paragraph 61, 1 and 2 from the same judgment, which I have already placed. After dealing with the relevant provisions, it was concluded, means by the Andhra Pradesh High Court, as under. We are therefore of the considered view and hold on point number 1. Then, Miller, your lordships have already seen what the Andhra Pradesh has said. Then paragraph 16. We have gone through
We have gone through the remaining paragraphs, including paragraph 17, where Raj process equipments.
Yes, Raj process and how SCG contracts has been distinguished. Right. Now, Miller, a division bench of another high court, that is the Telangana High Court, has also considered the question in a judgment which is not reported, but we have downloaded it from the website of the Telangana High Court. I'll give a copy to my learned friend. Paragraph 2, some parts of paragraph 2. Revision petitioner is plaintiff. In OS number 472 of 2016, on the file of Court of 9th Additional District Judge, Rangareddy District, for recovery of such. Respondents hearing are defendants. On service of summons from the civil court, defendants entered appearance on 18th of May 2016, but no written statement was filed within 120 days from the date of receipt of summons. Even without filing written statement, IA number such and such was filed under Order 14, Rule 2 CPC, challenging the jurisdiction of civil court. as the dispute involved is a commercial dispute consequent to establishment of commercial courts in Rangareddy district. The suit was transferred to the commercial court, that is special judge for trial and disposal of commercial disputes, Rangareddy district at LB Nagar, and renumbered as COS number 12 of 2018. After transfer of the suit to the commercial court, said IA was renumbered as IA number 18 of 2018. During the pendency of said IA, by order dated such and such, defendants were set ex parte on the ground that no written statement was filed within the time. By order dated such and such, IA number such and such was disposed of, giving liberty to the defendants to lead evidence regarding jurisdiction. Aggrieved thereby, CRP number such and such was filed. On 26 November, IA was filed praying to set aside order. By order, such and such was allowed, setting aside ex parte order and permitting the defendants to prosecute the suit. Aggrieved thereby, this revision is filed. Now, paragraph 3, according to learned counsel for petitioner, Order 5 of Civil Procedure Code was amended by the Commercial Courts Act 2015, which requires filing of written statement within a maximum period of 120 days from the date of receipt of summons. And if no written statement is filed within 120 days, the right to file written statement stands forfeited and the commercial court has no jurisdiction to relax this time frame. He would submit that even though it is a pending suit in a civil court transferred to commercial court, as per Order 8, Rule 1 of CPC as amended, 120 days period still remains, and in terms thereof, the written statement requires to be filed within 120 days. He further submits that admittedly the defendants have not filed written statement within time. Therefore, order of the trial court setting aside the order, placing the defendants ex parte to the suit on the ground that written statement was not filed within 120 days is illegal. Now, Millard, kindly come to paragraph 4. Per contra, according to learned counsel for respondents, as defendants were contesting the maintainability of the suit itself, they filed IA and they were waiting for disposal of said IA to take further steps. He would submit that in view of section 15, subsection 3 and 4 of the Act of 2015, the penal consequences of not filing the written statement within 120 days in terms of Order 5, Rule 1 and Order 8, Rule 1 as amended are not attractive. That as per CPC as applicable to civil proceedings, discretion is vested in the civil court to condone the delay in filing written statement and to consider application to set aside the ex parte order and to permit the defendants to file written statement. Since it is a pending suit before the civil court transferred to commercial court, on establishment of commercial court, the original provision in CPC is attracted and commercial court has got discretion to condone the delay in filing written statement by setting aside ex parte order. He would submit that section 15(4) requires determination of new timeline or issue such further direction as may be necessary for a speedy and efficacious disposal of a suit before the commercial court. In the instant suit, no such timeline is determined by the commercial court. And in the absence of determination of timeline, and in view of the provision contained in section 15, subsection 3 and 4 of the Act of 2015, the trial court rightly exercised its discretion to set aside the order permitting the respondents to file written statement. In support of his contentions, he placed reliance on Raj process. Now, Millard, kindly come to paragraph 8 at internal page 8. With avowed objective of expediting the disposal of suits involving commercial disputes, the Commercial Courts Act 2015 was promulgated. In order to ensure expeditious disposal, certain special provisions are made. By Act of 2015, some provisions of Civil Procedure Code were also amended. After establishment of commercial courts, the suits involving commercial disputes pending before the civil courts are required to be transferred to commercial courts to be tried in accordance with the provisions of Act of 2015 and amended CPC. Though Order 5 vests discretion in the civil court to condone the delay in filing written statement within the time granted by the court, and in a given case even to set aside the ex parte order, setting the defendants ex parte and permitting them to file written statement, as this particular aspect is also leading to avoidable delays, Order 5, Rule 1 is amended, imposing strict condition of fixing maximum time limit of 120 days to file written statement in a commercial dispute. If the written statement is not filed within 120 days from the date of receipt of summons, defendants lose their right to file written statement in case proceeds further without written statement. Even if there is genuine cause for the defendants is not filing written statement, the commercial court has no jurisdiction to condone the delay and to permit filing of written statement after 120 days. Section 15 of the Act of 2015 deals with transfer of pending cases. I'll skip this provision because this is paraphrasing the section again. Paragraph 10. From plain reading of subsection 4 of section 15 along with proviso, it is clear that a civil suit transferred to commercial court requires new timelines to be specified by the commercial court. This is very important. It is clear that a civil suit transferred to commercial court requires new timelines to be specified by the commercial court. And the new timelines so specified are applied notwithstanding any contrary provision as applicable to commercial suits filed under the Act of 2015. As a corollary, the restraint imposed in proviso to Subrule 1 of Order 1 of Rule 5 does not apply. In other words, the restriction on filing written statement within 120 days in a commercial suit is not attractive to a pending civil suit transferred to the commercial court. But on such transfer, the commercial court needs to prescribe new timeline. On further reading of subsection 4 and proviso, it is also clear that discretion is vested in the commercial court to prescribe the new timeline and new time period within which written statement should be filed. Though provision in section 15 is very clear, learned counsel for petitioner sought to contend that proviso to section 15.4 only covers proviso to Subrule 1, Order 5, Rule 1, but not applicable to Order 8, Rule 1 of CPC. According to learned counsel, Order 8, Rule 1 of CPC also requires filing of written statement within a period of 30 days with extended period of 90 days and total period of 120 days. It is a mandatory provision. As this requirement is not relaxed, if written statement is not filed within 120 days, the right to file written statement stands forfeited, and they cannot take advantage of provisions in section 15.4 anymore. Very same issue was raised before the Honorable Supreme Court in Raj Process Equipments and Systems Private Limited. Honorable Supreme Court considered the issue wherein holding that written statement was not filed within time granted, even though appearance was entered. The trial court, by order dated 3rd July 2018, set defendants 3 and 4 ex parte and forfeited the right of filing written statement by defendants 1 and 2 therein. On 11th of August 2018, District Court Jalgaon was designated as commercial court. The suit pending on the file of the civil court, civil division, was transferred to the commercial court. After the transfer of suit, defendants 1 to 4 moved 3 applications for condonation of delay, recalling the order of no written statement dated such and such, passed against defendant number 1 and 2, and setting aside the order, directing the proceedings to go on ex parte against defendant numbers 3 and 4. The commercial court rejected all the 3 applications by order dated 11th of April 2019 by placing reliance on proviso to order 8 Rule 1 of CPC. Said decision of the commercial court was affirmed by the High Court. The Honorable Supreme Court noticed that in accordance with proviso to Subrule 1 of Rule 1 of Order 5 of CPC and the proviso to Rule 1 of Order 8, the time to file written statement expired on 18th of June 2018 when the suit was pending before the civil court. The Honorable Supreme Court observed. Then the Supreme Court really goes on the basis of SCG contracts. Then paragraph 12.2. This very issue was also considered by the division bench of the High Court of Andhra Pradesh in Amoza Iron Steel Limited. The division bench formulated 2 issues for consideration. Then your lordships have seen what the Andhra Pradesh division bench has said, the judgment quotes from that. Then kindly come to internal page 14, paragraph 13. We are in respectful agreement with the opinion expressed by division bench of High Court of Andhra Pradesh, as rightly observed by learned division bench of High Court of Andhra Pradesh, forfeiture of right to file written statement will arise to a suit transferred from civil court only when commercial court prescribes new timeline. In Raj Process Equipment and Systems Private Limited, Honorable Supreme Court held that in view of decision in Salem Advocates, the proviso to Rule 1 of Order 8 of CPC is discretionary and not mandatory. And for normal civil suits, the proviso as existing in CPC applies. The commercial court exercised discretion to grant further time to file written statement. Therefore, we see no error in the decision of the commercial court. Learned Counsel petitioner cited several decisions. We have gone through the said decisions. Having regard to the issue involved and in view of provision contained in section 15 subsection 4 of the Act of 2015, said decisions have no relevance to the issue in the case on hand. It is vehemently contended that there was inordinate and unexplained delay in filing application to set aside ex parte order, and the commercial judge ought to have dismissed the application on that ground. Respondents have narrated the reasons for delay in not filing written statement immediately and not filing application to set aside the orders, setting them ex parte and seeking leave to file written statement. It cannot be said that the reasons assigned by the respondents are fanciful and imaginary, having regard to the timeline of events indicated in their application filed before the trial court. Then, Millard, on the question of law, be that as it may, having regard to provision in section 15 subsection 4 of the Act of 2015, we are of opinion that since no timeline is prescribed by the commercial court after the suit was transferred and no time limit is specified for filing the written statement, it cannot be said that respondents are not entitled to file application to set aside the order, setting them ex parte, and seek leave to file written statement. The commercial court has considered all aspects as urged before us, and in due assessment of the provisions of law and precedent decisions, the commercial court has come to the correct conclusion in allowing the applications filed by the respondents. The said order is passed on due application of mind, etc. Therefore, Millard, that is sustained. Now, Millard, I have cited division bench judgments of Andhra Pradesh, Madhya Pradesh, and Telangana. I, Millard, with your lordship's leave, will like to cite a view of our High Court, although by a learned single judge. I will seek your lordship's leave to adapt it as a part of my submission. Kindly treat it as a part of my submission because this is by a learned single judge. But however, since this is a pronouncement by our High Court on the issue, Millard, I thought that it is perhaps for the sake of completeness, this is also, Millard, not reported, taken from, copy has been taken out. Millard, kindly come straight away. I'll take your lordships only to the legal part of it because the factual part is the same. That is the case of transfer of a suit filed in the ordinary civil jurisdiction to the commercial division. Paragraph 43. In fact, Millard, my learned friends, learned senior, Mr. Devnath Ghosh had appeared in this matter, that I find. It is rightly argued by Mr. Ghosh, learned counsel for the plaintiff, that the suit, commercial in nature with specified value, is required to be transferred to commercial court in view of statutory mandate as laid down under Section 15 of the Commercial Courts Act 2015. The substantive law, since does not prescribe the procedure for such transfer, it can be effected, etc. Kindly skip the rest of it. They are only quoting. Kindly come to the learned judge considers a number of judgments. Kindly come to paragraph 58, internal page 25. Taking lumen from the aforesaid decision of Honorable Apex Court, it can be said that a suit when transferred under Section 15 of the Commercial Courts Act 2015 is to be considered not as continuance of the old suit, which is to be tried in commercial court. Rather, it has to be treated as fresh suit in view of the ratio laid down in ONGC, which the learned judge has referred to before. Then subparagraphs 3 and 4 of section 15 are quoted. Then 4 is also quoted in paragraph 60. Paragraph 61. Here in this case, the learned judge, commercial court, did not take recourse to proviso to subsection 4 of section 15 of the Commercial Courts Act, and also did not assign any reason for not adhering to such provision. Though subsection 4 of section 15 of the Act envisages that court may hold case management hearing, so according to Mr. Ghosh, learned counsel, it is not mandatory. Keeping in mind the fact that essence of law lies in the spirit and not in letter, but letters express the intention of the legislature, it is necessary to appreciate the legal import of the word may as used in subsection 4 of section 15 of the Commercial Courts Act to get the real intention of the legislature. If the provision of section 15 of the Commercial Courts Act, particularly subsections 3 and 4 are read, keeping in mind the laudable object behind the enactment, the statutory provisions do speak the mandate, leaving no room to exercise discretion. The word may is essentially to be read as shall. Otherwise, the object of all Commercial Courts Act 2015, the object of the Commercial Courts Act 2015 would be defeated. Then Miller's state of Punjab is quoted. Upon careful consideration of the statutory provision as laid down under subsections 3 and 4 of section 15 of the Commercial Courts Act, this court is of the opinion that a learned commercial court was under statutory obligation to take steps in consonance with the mandate laid down in the Statute of Commercial Courts Act 2015 and to hold case management hearing in respect of such transferred suit in order to prescribe new timelines, and for that should have issued such further direction as could be necessary for efficacious disposal of such suit in accordance with Order 15A of the Code of Civil Procedure. There is no reason to differ with the view of the Honorable Apex Court as expressed in such and such. But in this case, the defendant appeared and filed petition under Order 7, Rule 11 of the Code of Civil Procedure before the suit was reserved for judgment. The defendant cannot be left at large without remedy only because learned trial court, after conclusion of argument ex parte, reserved the suit for judgment, ignoring the presence of the defendant before it. In that event, it would be a travesty of justice. Surprisingly, the learned trial court has not disposed of the suit till date, although there is no order, etc. The defendant was, paragraph 67, the defendant, though, was not allowed to set the clock back, but he has every right to challenge the proceedings, which he had done by filing petition under such and such. While taking the said petition on record without returning the issue raised, the learned trial court could not have reserved the suit for judgment. In my humble opinion, the learned court committed jurisdictional error by denying the defendant the opportunity to join the proceeding as required under Rule 7 of Order 9 or Order 9, etc., and by not adhering to the provisions of Section 15, subsections 3 and 4 of the Commercial Courts Act 2015 in its letter and spirit. It reminds the court the observation made by the Privy Council in Nazir Ahmed. Your lordships are familiar with that. The object of 227 is discussed, then the revisional application is allowed. And in paragraph 72, the learned trial court is directed to comply with the provisions of Section 15 of the Commercial Courts Act in letter and spirit. Therefore, Miller, this is again a reaffirmation of the position laid down by the other high courts that in case of a transferred suit, the new provision or the new timeline has to be prescribed. And in some parts of the judgment, the learned judge has used the expression that it is mandated and the court is obliged to do so. Miller, I am adopting the ratio as a part of my submission.
You also honestly believe it is mandatory in spite of the language of 15.4.
Yes. But my submission is, as I indicated at the beginning, that even if your lordships are not with me on the question of mandatory, this is a relevant consideration to be taken into account by the commercial court in a transferred suit while considering the question of filing of written statement. And perhaps the learned single judge could not have, because he considered this application after transfer in the non-commercial division, the learned single judge could not have adverted to section 15(4) also, because this is a statutory regime. This is a distinct and different, qualitatively different statutory regime, which can be invoked, exercised, and adhered to by a court exercising jurisdiction under the Commercial Courts Act. Miller, the secretary of all this.
Did he have determination of commercial matters also?
Lot.
On the relevant date, did the honorable judge have determination in respect of commercial matters also?
Of both commercial and non-commercial. I have in fact included the cause list, Miller, in the paper. But my submission is that whatever it may be, because the learned judge was considering it in the non-commercial division, he could not have, he did not in any case, but he could not have also adverted to this statutory regime, because a court exercising ordinary original civil jurisdiction would not be entitled to invoke section 15 subsection 4, because only a transferee court in such a situation, the commercial transferee court, can take into account section 15 subsection 4. In any case, section 15 subsection 4 was not adverted to at all. Miller, the sequitur of this argument is the next part. Is that by reason of this, what I have just now submitted, that matter that an application for extension to file written statement would not have been considered in respect of this suit in the non-commercial division at a point of time when the suit to transfer to the commercial division renders, Miller, the court which purported to pass this order, the impugned order, the court which passed the impugned order, a quorum non juris, and therefore the order is a nullity. Miller, I'll give a few judgments on that. Yes. First, which is C.S. Goenka. How much very heavy? Chiranjilal Srilal Goenka. Miller, the first judgment which I wish to cite is reported at 1993, Volume 2, Supreme Court Cases, 507. Miller, I only place, for the purpose of the legal proposition, Miller, three paragraphs, 18, 19, and 20. Paragraph 18 at page 517. At page 517.
Yes.
Paragraph 18. It is settled law that a decree passed by a court without jurisdiction on the subject matter or on the grounds on which the decree made, which goes to the root of its jurisdiction or lacks inherent jurisdiction, is a quorum non juris. A decree passed by such a court is a nullity and is non-est. Its invalidity can be set up whenever it is sought to be enforced or is acted upon as a foundation for a right, even at the stage of execution or in collateral proceedings. The defect of jurisdiction strikes at the stage of execution, strikes at the very authority of the court to pass the decree, which cannot be cured by consent or waiver of the party. In Bahadur Singh, etc., an eviction petition was filed. The dispute was referred to arbitration. An award was made directing the tenant to run the workshop up to a specified time and thereafter to remove the machinery and to deliver vacant possession to the landlord. The award was signed by the arbitrators, the tenant, and the landlord. It was filed in the court. A judgment and decree were passed in terms of the award. On expiry of the time, and when the tenant did not remove the machinery nor delivered vacant possession, execution was levied under Delhi and Ajmer Rent Control Act. It was held that a decree passed in contravention of Delhi and Ajmer Rent Control Act was void, and the landlord could not execute the decree. The same view was reiterated in Kaushalya Devi. In Firoz Lal, a compromise divorce grounds for eviction was arrived at between the parties under Section 13 of the Delhi and Ajmer Rent Control Act. A decree in terms thereof was passed. The possession was not delivered and execution was late. It was held that the decree was nullity and therefore the tenant could not be evicted. In Sushil Kumar Mehta versus Govindram Bohra, the civil court decreed eviction, but the building was governed by Haryana Urban. It was held that the decree was without jurisdiction and its nullity can be raised in execution. In Union of India versus Ajit Mehta and Associates, a division bench to which Justice Sawant, as he then was a member, was to consider the validity of the award, was to consider whether the validity of the award could be questioned on jurisdictional issue under Section 30 of the Arbitration Act. The division bench held that Clause 70 of the contract provided that the chief engineer shall appoint an engineer officer to be sole arbitrator, and unless both parties agree in writing, such a reference shall not take place until after completion of the works for termination or determination of the contract. Pursuant to this contract under Section 8 of the Act, an arbitrator was appointed and award was made. Its validity was questioned under Section 30 thereof. The division bench, considering the scope of Section 8 and 20 subsection 4 of the Act, and on review of the case law held that Section 8 cannot be invoked for appointment of an arbitrator unilaterally, but Section 20 subsection 4 of the Act can be availed of in such circumstances. Therefore, the very appointment of the arbitrator without consent of the parties was held void, being without jurisdiction. The arbitrators who were appointed inherently lack jurisdiction, and hence the award made by such arbitrator is non-est. In Gelavai case, Chief Justice Sir Farhan Knight, Chief Justice of Bombay High Court, held that the probate court alone is to determine whether probate of an alleged will shall issue to the executor named in it, and that the executor has no power to refer the question of execution of will to arbitration. It was also held that the executor, having propounded a will and applied for probate, a caveat was filed denying the execution of the alleged will, and the matter was duly registered as a suit. The executor and the caveatrix subsequently cannot refer the dispute to arbitration, signing a submission paper. But such an award made pursuant thereto was held to be without jurisdiction. I am skipping paragraph 19, Miller. Paragraph 20, on a conspectus of the above legal scenario, we conclude that the probate court has been conferred with exclusive jurisdiction to grant probate of the will of the deceased. Miller, in our case, Miller, the commercial division, the court exercising commercial jurisdiction in terms of a statute, has been vested with exclusive jurisdiction post-transfer to deal with the suit, to grant probate of the will of the deceased annexed to the petition. On grant or refusal thereof, it has to preserve the original will. The grant of probate is final, subject to appeal if any, or revocation if made in terms of the provisions of the Succession Act. The judgment in rem and conclusive and binds not only the parties but the world. The award deprives the parties of statutory right of appeal provided under Section 299. Well, pausing here for a moment, it deprives the appellant from availing of its statutory rights under Section 15, subsection 4. Thus, the necessary conclusion is that the probate court alone has exclusive jurisdiction, and the civil court on original side or the arbitrator does not get jurisdiction, even if consented to by the parties, to adjudicate upon the proof or validity of the will propounded by the executrix. It is already seen that the executrix was nominated expressly in the will and is a legal representative entitled to represent the estate of the deceased, but the heirs cannot get any probate. before the probate court, they are entitled only to resist the claim of the executor of the execution and genuineness of the will. The grant of probate gives the executrix the right to represent the estate of the deceased, the subject matter in other proceedings. We make it clear that our exposition of law is only for the purpose of finding the jurisdiction of the arbitrator and not an expression of opinion on the merits of the probates. 2009 4SC. Actually, একটা দিয়ে দাও কপি আমাকেও দিয়ে দাও Yes, Millard. The next decision I'm relying on is reported at 2009 Volume 4 Supreme Court Cases 625. Now, kindly come, Miller, to paragraph 12 at page 628. As indisputably the director of a pre-university education is an authority created under a statute and not a court, by no stretch of imagination, it cannot be described as a court so as to enable the first respondent to file an application for initiation of proceedings under the Contempt of Courts Act against the appellant hearing for willful disobedience of the order of the director. Pre-university education, especially when an appeal against the said order is still pending. The order of the statutory authority thus would not alleviate the provisions of the Contempt of Courts Act. The impugned orders thus are wholly illegal. The High Court, therefore, in our opinion, had no jurisdiction to initiate any proceeding under the said Act. Learned counsel for the first respondent, however, submits that such a contention had not been raised before the High Court. Since the director pre-university education was not functioning as a court within the provisions of the Act, in our opinion, the impugned order of the High Court taking cognizance of the said application as also directing to frame charge is wholly without jurisdiction and non-est in the eye of the law, and therefore is unsustainable. It was coram non judice. Such a contention can be raised at any stage. Only few paragraphs from another judgment in page. Yes, sir. 2023, well, the next judgment I'm citing is reported at 2023, 1 Supreme Court cases 549. Kindly come to 549. Kindly come to paragraph 25 at page 561. It is also, sorry. It is also required to be noted, paragraph 25 at page 561. It is also required to be noted that even as per Section 15 of the 2015 Act, all suits and applications, including applications under the 1996 Act relating to a commercial dispute of specified value, shall have to be transferred to the commercial court. Even as per Section 21 of the 2015 Act, the 2015 Act shall have overriding effect. It provides that, save as otherwise provided, the provisions of this Act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Therefore, considering the aforestated provisions of the 2015 Act and the objects and reasons for which the 2015 Act has been enacted, and the commercial courts, commercial division and commercial appellate division in the high courts are established for speedy disposal of the commercial disputes, including the arbitration disputes, sections 3 and 10 of the 2015 Act shall prevail, and all applications or appeals arising out of arbitration under the provisions of the 1996 Act, other than international commercial arbitration, shall be filed in and heard and disposed of by the commercial courts exercising the territorial jurisdiction over such arbitration where such commercial courts have been constituted. If the submission on behalf of the appellants that all applications arising out of arbitration under the provisions of the 1996 Act, other than the international commercial arbitration, shall lie before the principal civil court of a district, in that case, not only the objects and reasons of enactment of the 2015 Act and establishment of the commercial court shall be frustrated, even sections 3, 10, and 15 shall become odious and nugate. If the submission on behalf of the appellants is accepted, in that case, though with respect to other commercial disputes, the applications for appeals shall lie before the commercial courts established and constituted under Section 3 of the 2015 Act. With respect to arbitration proceedings, the applications for appeals shall lie before the principal civil court of a district. There cannot be two fora with respect to different commercial disputes. Under the circumstances, notifications issued by the state of Odisha in consultation with the High Court of Odisha to confer jurisdiction on the court of the learned single judge designated as commercial court to decide the applications or appeals arising out of arbitration under the provisions of the 1996 Act cannot be said to be illegal and bad in law. On the contrary, the same can be said to be absolutely in consonance with Section 3 and 10 of the 2015 Act. We are in complete agreement to the view of the High Court. Therefore, my lord, what the court says in this case is that in respect of matters which attract the jurisdiction of the Commercial Courts Act and which either by original institution or by transfer are to be tried. Sorry. You don't see. And therefore, sorry. Yeah, sure.
Mr. Chatterjee, kindly continue after recess and complete.
Yes,
yes.
I
Mr. Ghosh,
take more than 20 minutes after.
we only want you to consider one point. These you need not deal with. What is there is there. Is it not creating a problem that on this particular day, the judge may have had both determinations, commercial and non-commercial, but this cause, this suit, was not marked as a commercial suit.
It was not marked in a commercial suit, no dispute, but the honorable judge had both determined. It's
That's
a
all
question.
right.
Wearing the cap in, then what is the effective law? But it's a nullity, whether it's not a nullity. It's merely, if it was if subject to correction in the other garden rich matters, some research I had done, if he had a jurisdiction, because I also did not get that It's lordships got that rather If he didn't have any any determination at all of that particular list, then the case of garden rich Supreme Court governs, it becomes a nullity. Otherwise, it's not. Second point, I also am hearing, it's a question to be decided, it's a suit, which qualifies both as a specified value as well as a subject matter. So it's a commercial code. It's before a forum, it's not in A list, but in B list. A list is commercial, B list is there. So he has passed an order, he had both the determination. So he was competent to pass. Now my learned friend, if he was competent to pass as on this date, as a commercial matter, whether any appeal will lie, because it was
that
a
I will address. That I will address.
I mean, sir, whether an appeal will lie, because if it has to be then if it falls within the ambit of the commercial code 15.4 etc etc. 15.4 is a concept of commercial codes act.
But did he treat it as a commercial suit or as a non-commercial suit?
He had determination.
Because different laws will apply.
They filed it. It's not my application. I am not to be faulted. It is they filed it as a non-commercial matter.
Yes, because by that time the transfer had not taken place.
Let us come back. Let us come back.
They filed it, right? And
I'll point
even
out
on
the
a
date
transfer
on which
suit,
it was filed.
Now, today the difficulty is more for my learned friend. After the promulgation of this commercial courts procedural rules. The rules say that this appeal, maybe a pending appeal, whatever, has to be tried by the commercial court, commercial division, and not by the original division. If that be so, then appeal is itself not maintainable, and this is exactly held by this court.
Well, I shall answer that when it is.
I'm just sounding to your lordship. This is the problem after
Anyway, all we are requesting both of you, please continue after 2 o'clock. Let us don't force us to take up a new matter.
This I should get a chance to prepare.
Why aren't you prepared? You are always prepared.
No, kindly give me a chance to today. 2 o'clock, don't give me. It's a difficult matter, to argue. Give me wait half an hour. Let's fix it, or 20 minutes.
Anyway, let Mr. Chatterjee finish first.
Let it only. It's a difficult.
হ্যাঁ যাচ্ছি কিন্তু গুছিয়ে রেখে দিতে ঠিক আছে 5 মিনিটে চলে আবার কতদূর ভাবে নিচের পর
দোকানে হয়ে গেছে আমি টিভিটা নিয়ে আসছি চাবি চাচ্ছি কোথায় টিভিটা তো গাড়িতে আনতে আনলি না থাক আমি তো থাকবেন না ঢুকে দেখো খেতে যাবো না আমি তো থাকবেন তো আমি খেতে যাবো না বলছি ছত্তিশগড় হাইকোর্টে যাওয়া বিরাট মানে সত্যি জান কি হয়ে যাবে ট্রেনে করে ধরো গেলে সন্ধ্যাবেলা বিরাট শুরু না হবে রাত্রে ওভারনাইট গেলেন ট্রেনে কটায় না দিয়ে সারাদিন ধরুন কোর্ট করলেন আবার রাত্রিবেলা ট্রেন ধরে তারপরে আপনি কটায় পৌঁছে যাবেন হাওড়া কটনের রাস্তা মানে মানে কথা বলছি কথা বলছি কথা বলছি কথা বলছি বলছি দিচ্ছি মোটামুটি কত নেবে কত নেবে না না আমার মাঝে আগিয়ে শিখে অমিত দা আমার মাঝে আগিয়ে শিখে মাঝখানে আমাদের আগে দেখে মামলা হয়েছিল আমার 38 জনের একটু স্যার পেয়ে গেল আমাকে ওইখানে আপনি কত তবু কত কত কত
Yeah, my lord, leave to mention a matter. My lord, I understand it's out of turn. My lord, I'm praying for leave to, my lord, file without certified copy and for urgent hearing, my lord. My lord, it is a matter, my lord, of an ex parte order passed, my lord, under Section 9 of the Arbitration Act, my lord, where my vehicle was directed to be taken into actual possession by a receiver. My lord, this order was not served on me for over a month. All of a sudden, my lord, it was implemented. Yes.
File it. When was the order passed?
My lord, on the 28th of July,
But it
not
was
served on me.
Very well. File it. Give the number, it will be listed.
I am grateful, man. I am grateful. Get out. One, sorry.
Yes, Mr. Mukherjee. Chatterjee.
Well, just one more decision on the point of jurisdiction, then I'll move on to the other points. Well, this is reported in 1954, Volume 1, Supreme Court Cases 710. Just one paragraph, paragraph 6. Hey, it is only for the proposition and nothing else.
1954.
Very prettily put, if I may say so, with respect.
Go back कर दीजिए उधर. अच्छा. কবে অবধি করেছে? 14 থেকে. আচ্ছা. Paragraph 6.
Paragraph 6 at page 717. The answer only for the proposition. The answer to these contentions must depend on what the position in law is when a court entertains a suit or an appeal over which it has no jurisdiction, and what is the effect of Section 11 of the Suits Valuation Act is on that position. Well, the Suits Valuation Act, Section 11 corresponds almost is perimeteria with Section 21 of CPC, which says that on the ground of lack of territorial jurisdiction or pecuniary jurisdiction, a decree cannot be faulted as without jurisdiction if the point is not taken. But the general I am on the general proposition, not Millard. It is not a case of territorial or pecuniary. The answer to these contentions must depend on what the position in law is when a court entertaining a suit or an appeal over which it has no jurisdiction, and what the effect of Section 11 of the Suits Valuation Act is on that position. It is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of the subject matter of the action, strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of parties. If the question now under consideration fell to be determined only on the application of general principles governing the matter, there can be no doubt that the District Court of Munger was coram non judice, that its judgment and decree would be nullities. The question is, what is the effect of Section 11 of the Suits Valuation Act on this position? I'll not go into that, because by construing Section 11, the court ultimately came to the conclusion that this is a question of lack of pecuniary jurisdiction, and therefore Section 11 saved the suit or save the decree from being without jurisdiction. But the general principle is this. Now, Millard, having concluded this aspect, Millard, I will, Millard, I'll submit that my learned friend, and I'm anticipating that this will be his submission, has already indicated that the fact that the learned judge had determination on the material date on which the impugned order was passed, both in respect of commercial matters and non-commercial matters, negates the contention that the order is without jurisdiction. Because, as he put it, it is a question of which hat the same judge was wearing while passing the order. Millard, I submit with respect, Millard, that this submission is misconceived for the reason that the same learned judge may, on a given date, exercise different jurisdictions under different statutes. For example, Millard, take the instance of the scenario which existed prior to the transfer of company matters to the Company Law Board and now the NCLT. The High Court had jurisdiction over the Companies Act. And at the same time, the High Court had jurisdiction in respect of original suits. Now, Millard, there have been many instances where questions of oppression and mismanagement have been agitated in a suit, although normally the special remedy for oppression and mismanagement at that point of time was sections 397 and 398. Now, Millard, it is very much possible that a learned judge of the High Court had determination on the same day in respect of matters under the Companies Act as also suits or interlocutory matters. Now, Millard, this does not cure the defect of jurisdiction, Millard, because on the same allegations or same issues, the learned judge, while exercising original civil jurisdiction, could not have invoked the powers under section 402 of the Companies Act, over which he also had jurisdiction on the same day, in the matter of dealing with oppression and mismanagement. Like your lordships know, Millard, that section 402 of the Companies Act is a very special remedy, extraordinary remedy in the context of sections 397 and 398, where the court could have ordered a reduction of share capital by cancelling shares without following the procedure prescribed in the Companies Act. The court could have ordered a buying out, as was laid in Scottish Cooperative under the Scottish law and then followed by the English courts and the Indian courts. As the same learned judge, sitting on the same day, exercising both determinations, he could not have, while exercising jurisdiction under the ordinary original civil jurisdiction, in respect of a suit involving a company dispute of oppression and mismanagement, he could not have invoked section 402, because 402 is a follow-up of the procedure prescribed or the remedy prescribed under sections 397 and 398. And only when the learned judge is exercising jurisdiction under sections 397 and 398, he is entitled to avail of the powers under section 402, the rather wide and extraordinary powers, where he can even supplant the provisions of a statute. It is almost similar in a general context like Article 142 of the Constitution. It is like exercising that power in a company's scenario. Section 4, there are numerous judgments which have said that. Millard, I'm not going into that. Therefore, Millard, my humble submission is that the fact that the same learned judge, or rather the person concerned, had both determinations, would not, Millard, clothe him with a jurisdiction which is different from the jurisdiction in which he passed the order. And in this case, section 15(4) makes a marked difference, because while exercising jurisdiction or exercising ordinary original civil jurisdiction, the learned judge would not have invoked section 15 subsection 4 proviso, which is required to be invoked in the case, or rather the defendant has a right to invoke in the case of a transferred suit. Whether it is mandatory for him to fix a new timeline is one matter, but it follows as a without any ambiguity that he has to at least advert to that aspect of the matter and come to a finding while exercising commercial powers that even under section 15(4) I am not satisfied and therefore I am not fixing a new timeline. And the impugned order does not contain any reference to section 15(4). And Millard, I can hear a whisper that it was never raised. For that, Millard, I cited the authorities that it is not required to be raised if it is quorum non judice and anality. Nothing can cure that, even consent, non-raising it, etc. It is ultimately for your lordships to consider, and I will reply when my learned friend deals with it in more detail. Now, Millard, this appeal, I'll come to section 13, the bar under the Commercial Courts Act, because that was also pointed out in the beginning, that my learned friend Mr. Devnath Ghosh said that he has an objection to the maintainability of the appeal in the commercial division, because according to him, there is a bar under section 13(1) capital A of the Commercial Courts Act, because this is not an order prescribed under order 43 of the Code of Civil Procedure, and therefore letters patent stands overridden by virtue of section 13. But before coming to that, Millard, because this order was passed in the non-commercial division, the ordinary original civil jurisdiction, my submission is that this has to be treated as a judgment within the meaning of clause 15 of the letters patent, because it denies the right to file written statement and therefore shuts out my defense in the suit. A very valuable right of mine is being taken away. Whether rightly or wrongly is a different question, but it certainly qualifies as a judgment within the meaning of clause 15 of the letters patent. Well, I'll not trouble your lordships with placing the judgments. For the sake of record, I'll give your lordships the copies and the paragraph numbers. Your lordships have gone through them numerous times. First, Millard, that Shah Babu Lal Khimji, it is reported at 1981, 4 Supreme Court cases. Page 8. Millard, I am relying on paragraphs 113 into brackets 3, paragraph 115, 116 and 120. I'll not take up 116 and 120. Well, I'll not trouble your lordships by reading the whole of it. It's a long judgment and your lordships are aware of the principles. The other judgment which I am relying on this question is the Calcutta Chemical Company, which is 1983 SCC Online, Calcutta, 84. Here there are 2 paragraphs. May I read them? Paragraphs 13 and 14. It says, Millard, paragraph 13, it is true that the impugned order is an interlocutory order, but the question as to whether it is a judgment under clause 15 or not will depend upon the nature of prejudice it has caused to the company. In the decision of the Supreme Court in Shah Babu Lal Khimji versus Jayaben, it has been observed by Justice Fazal Ali in paragraph 115 of the report as follows. Thus, in other words, every interlocutory order cannot be regarded as judgment, but only those orders would be judgments which decide matters of moment or affect vital and valuable rights of the parties and which work serious injustice to the party concerned. Similarly, orders passed by the trial judge deciding question of admissibility or relevancy of a document also cannot be treated as judgments, because the grievance on this score can be corrected by the appellate court in appeal against the final judgment. The above observation has been strongly relied upon by learned counsel for the respondent numbers 1, 2, and 3 in support of the contention that the impugned order is not a judgment and hence not appealable. In our view, however, the observation leans against the contention of the learned counsel. The impugned order is not as simple as an order deciding the question of admissibility or relevancy of a document, but it has impliedly decided matters of moment and has caused serious prejudice to the company. The reports of S.R. Batleyboy and company contain certain findings and comments against the company. Such findings and comments, which are the sheet anchor of the respondent numbers 1, 2, and 3, if not allowed to be dealt with or controverted by the company, there is every possibility of the final decision going against the company, resulting in the supersession of its board of directors and appointment of a special officer or administrator. There can therefore be no doubt that by the impugned order, the company has been seriously prejudiced. We do not find any substantial distinction between the nature of prejudice suffered by a defendant in a suit whose written statement is struck out, or who is not permitted to file a written statement, and that suffered by the company in the instant case by the dismissal of its application for leave to file a supplementary affidavit in defense against the prayer for supersession of its board of directors and appointment of a special officer or an administrator to take charge of the company. It may be that the impugned order can be challenged in appeal against the final judgment, disposing of the application under sections 397 and 398 of the Companies Act, as contended on behalf of the respondent numbers 1, 2, and 3. But in our opinion, the contention is quite relevant to the serious prejudice that has been caused to the company by the impugned order. An interlocutory order, unless made expressly appealable by any statute under which it is passed, can always be challenged by the aggrieved party in an appeal from the judgment disposing of the proceeding. The seriousness of the prejudice or injustice caused to an aggrieved party by an interlocutory order is the guiding factor for the decision of the question as to whether such an order is a judgment within the meaning of clause 15 of the latest pattern. We are therefore of the view that the impugned order is a judgment under clause 15 of the latest pattern, and consequently the appeal is quite maintainable. The contention to the contrary is overruled. Therefore, my lord, even in the case of non-filing or refusal to allow the parties to file a supplementary affidavit, it has been held to be a judgment, and they say, the division bench says, that that is no less a prejudice than what is suffered by denial of an opportunity to file a written statement. Impliedly, my lord, denial of an opportunity to file a written statement is a matter of great prejudice. Following Shah Babul Al-Khimji, this has been held. Now, my lord, I deal with the contention of my learned friend that the appeal is barred under the Commercial Courts Act because, according to him, if the matter ought to have been treated as a commercial matter, and the fact that the learned judge was also exercising commercial jurisdiction, and therefore the order should be treated as deemed to be an order in exercise of his commercial jurisdiction, and therefore barred. Well, kindly take the Commercial Courts Act.
The act of court. The attempt appropriate হবে ট্রান্সফার করে সাবজেক্ট টু ইয়ে ট্রান্সফার করে আবার শুনতে পারে non-commercial side. Okay, subject to what they say. Maybe is no case at all. Yes.
Yes. Millard, kindly take the Commercial Courts Act once. Section 13. Section 13, 1 capital A. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order, provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure 1908, is amended by this Act, and Section 37 of the Arbitration and Conciliation Act 1996. My learned friend Millard contends, subject to correction, that because this order can be deemed to have been passed in exercise of jurisdiction under the Commercial Courts Act, and not being an order specified in Order 43 of the Code of Civil Procedure, no appeal lies, and because Millard, kindly come to subsection 2, notwithstanding anything contained in any other law for the time being in force or latest patent of a high court, no appeal shall lie from any order or decree of a commercial division or commercial court, otherwise than in accordance with the provisions of this Act. Therefore, to that extent, Millard, the latest patent, including clause 15, stands overridden. And therefore, my learned friend contends that because this is not an order, although deemed to be passed under the Commercial Courts Act, but not enumerated in Order 43, therefore, Millard, no appeal shall lie to the commercial division against this order. Millard, my submission is that I am not before the commercial division because your lordships are exercising appellate powers in respect of non-commercial matters. And this order, although erroneous, although ought not to have been passed in the ordinary original civil jurisdiction, was in fact passed in exercise of ordinary original civil jurisdiction. Therefore, Millard, this will not qualify as such an order because it says any person aggrieved by the judgment or order of a commercial court. The impugned order, in fact, is not an order of a commercial court, according to me, and has been passed, in fact, in exercise of ordinary original civil jurisdiction and not as a commercial court. Therefore, it is not a judgment and order of a commercial court. And therefore, the bar does not apply. The latest patent does not stand overridden. And if it qualifies as a judgment within the meaning of clause 15 of the latest patent, an appeal will lie in the non-commercial side, as we have done in the instant case. My learned friend has also argued, of course, I will answer him in reply, but only last point. My learned friend has also argued that this appeal cannot be considered by your lordship in this jurisdiction because of the same reason that it is deemed to be passed by a commercial court, etc. And it has to be considered in the proper forum, etc. Well, and if that is so, that because it was passed by a because it was because the appeal ought to have been preferred before the Honorable Supreme Court under Article 136, if at all, being a commercial matter, then as a necessary corollary, it follows that my application would not have been considered by the learned judge in the non-commercial jurisdiction, because therefore, this argument is mutually destructive. If it has to be treated, my learned friend concedes that it has to be treated as a commercial matter. It ought to have been treated as a commercial matter. Then the learned judge, and therefore no appeal lies here, then the learned judge also could not have considered in the non-commercial jurisdiction. For the time being, these are my submissions, I will reply once my learned friend completes his arguments.
When?
15th, my junior is not there.
Today is the 3rd, Mr. Ghosh.
Very well, next week, any late lordship, you should permit him to join online.
Yes, he can join virtually.
When lordship takes up the next matter on the roster?
Fridays or holiday next
Wednesday.
Very well.
Yes, because the list gets called
On Wednesday.
mostly on.
I am here, lordship will permit him to join.
Mr. Chatterjee, learned senior advocate representing the appellant, resumes his argument and concludes his opening submission. Paragraph, as requested by Mr. Debnath Ghosh, learned senior counsel representing the respondent, list this matter once again on Shamnir Budbar.
10th, it's 10th. Wednesday.
Under the same heading.
And retaining its position.
Yes.
They're fairly at the top.
Next week.
Wait. Much open.
Item number 16.
Lordship, I'm praying for a not today, Lordship. I'm led by Mr. Shakushan in this matter. This is my application. I just praying for a short passover, Lordship. I'll call back Mr. Shakushan.
May I? The appeal arises out of a decree, suit for eviction, and occupation charges. Suit was decreed.
You are the plaintiff.
I am the plaintiff. The appeal was preferred, maybe after about 6-7 days. Yes, more than 2 years or about 2 years thereafter. Delay was condoned, and thereafter, they were a conditional order was passed that they shall put in certain sum of money, and they would go on paying at a fixed rate the occupation charges.
I take the liberty of interrupting.
No, may I?
My application,
I know. What I am trying to say, will possibly
not a very good case for allowing Mr. Mitro to tell my case.
Now, thereafter, they did not comply with that order, and ultimately the appeal was dismissed for default. Now, after several years, the application for restoration, that is, appearing before your lordship. In the meantime, my client, had put the decree into execution. In that, the executing court has passed an order saying that, they will deposit certain sum of money with the registrar original side by a particular date, maybe by 12th of this month, I would humbly submit that kindly take up this appeal after that, Let them come up with the money, Let us see the color of the money.
Yes, this is a restoration.
Restoration application.
No, come back up. Let us see what happens on the 12th, Mr. Sen.
12th. 23rd.
No.
Come back up to 23rd.
No, that we have to deposit it within 23rd.
No. 12. 2 weeks from my lord 26, which comes to my lord 11th. Kindly take it up on 12th or my lord 13th.
17th.
But we have there also there is a mediation and we have to.
Mediation.
Mediation, my lord, about the interest. The decree, my lord, provides interest at a particular rate. I really.
But it is a question of interest on damages.
No, Mr. Sen, come back after on the 17th.
Yes,
Come back on the
occupation
17th.
But then, my lord, kindly keep it on 19th. My lord, I
19th,
will
very well.
not be available. My lord.
19th.
Personal difficulty, I will not be
19th.
coming, my lord.
We are told that the executing court is likely to take up the matter on or around 30? 11th.
11th.
No, money, deposit of money
Deposit
is by,
of money was to be by.
When is the matter returnable before?
23rd of September.
Is on September 20, on or about na? On
Yes,
September
23rd.
23, 2025. Stop. In the meantime, the appellant herein is required to deposit certain amount with the trial court,
Register original side.
with the registrar original side of this court.
Yes.
Oh, this is single judge of our court.
Yes.
Oh, I see. Trial court football. Before the learned, we are told.
Huh? Appeal to
Registry original side of this court. Stop. Paragraph. Let this matter be listed again on September 19,
May I file the affidavit
2025,
in opposition in this
retaining its position. Paragraph affidavit in opposition filed on behalf of the respondent and the appellant's reply thereto in connection with the
GS6
restoration application be kept with the records.
But I was submitting, my lord, the appeal could have been restored, my lord.
Correct.
This is sufficient. I will remember and make your lordship remember also. God bless. I will not open the brief, my lord, next day for restoration.
Appeal for old matter. Item was 17 and 18.
Ahmedabad. Not Ahmedabad. Dhanbad.
Lordship, Mr. Dhruvo Ghosh is appearing for one of the.
Has he not come back from Ladakh?
He has come back, Your Lordship, but he's on legs or has gone to some other place. I don't know, Your Lordship. I'm praying for an accommodation today, Your Lordship.
Only this, my lord, I'm for the depositor, the plaintiffs. There are various depositors. It's between the tussle between Mr. Dhruvo Ghosh's client and Mr. Mitro's client, for which the depositors are being prejudiced. Near large sum of money is due and payable.
Ensure his presence on the next day.
That is a very difficult task. Your Lordship will kindly give us, or Your Lordship will retain
Yes,
this
not
matter.
today. Yes. On the ground of non-availability of learned senior counsel for the appellant in.
Appellant, the next matter in 7.
He is for movement traders.
No, I'm for
For
movement.
Oh,
Tajul Mulk.
Tajul Mulk.
Yes.
Appellants in APO 489 of 2015, this matter stands adjourned for the day. Stop. Just stands adjourned for the day. It should stop. The matters should retain their position in the list.
That will be possible.
I'm grateful.
Substantive order.
We should do the last part.
Item number 19.
Item number 19, Your Lordship had the pleasure of directing Alex Stewart to carry out the valuation. So, what I have understood is they will be taking another 10 days time to file the report. Now, if Your Lordship will kindly.
Your senior is joining from England? No.
No, he's not joining from me.
Very well. Will adjourn it?
Me along. He should have.
Should have. We'll adjourn it for a fortnight.
Yes, but if your lordship would kindly direct.
My lord, they are doing their job, my lord. It will take as submitted. It's another 10-15 days.
Yeah, last order to the.
Make it peremptory because they now have to file the report, because at the instance of LMJ, they had asked for two things to be calculated. One is CSR and the other is CRP.
They are not parties to the suit.
Yes, but
We will make an observation. We'll make an observation.
They should file the report in another 10 days.
Yes.
Because the matter was made returnable, they were supposed to file.
Pursuant to our order dated August 6, 2025, Alex Stewart International bracket India bracket close private limited আগের order থেকে দেখে নিও has been engaged for valuing the coke in question. Paragraph. Learned advocate for the respondent number 1.
Yes, applicant, respondent number 1.
Respondent number 1 / applicant says that the valuer has said that it will take some more time to prepare the valuation report. Paragraph. Paragraph. The valuation report should be prepared within the next 10 days. Stop. List the matter once again. A fortnight hence date ta diye dao. Paragraph. A copy of this order. Let this order be forthwith communicated by learned advocate on record for the applicant to Alex Stewart.
And so far as the other directions are concerned, my lord, so our client have complied with it regarding the remuneration, additional remuneration. Those are complied with.
Very well.
Grateful, dear lord.
Right moment.
Right moment.
Right moment.
Photo finish.
It's not only horses who do that. Lawyers, we do it also.
The matter is made returnable on 17th.
17th.
Grateful, dear lord.
2 weeks for it.
17th.
Are you nurturing your musical talents? No, you've given it up altogether.
I haven't given it up altogether, but
Don't do that. You'll regret later, I can tell you.
my daughter doesn't allow me to sing. That's the problem. She doesn't allow me to sing.
Bribe her.
Lord, I hope that's also.
Yes, yes.
That should also be followed, my lord.
You're aware of that.
Yes.
Number 20.
My lord, I appear
Or the respondent.
My lord, I appear for the appellant. I'm led by Miss Nilanjana Adhya in this matter. My lord, I'm seeking a short passover.
Passover.
Much obliged.
21.
Well, I'm praying for not today only.
You're appealing for?
Appellant, my lord.
Yes.
Praying for not today, my lord.
Why?
Mr. Sarvapri on the ground of Mr. Sarvapri Mukherjee, my lord. I think he's
Sir,
in...
they have concluded their submission. It's our turn to
Yes.
the submission. I am led by Mr. Ranjit Chaudhary appearing for the official liquidator, my lord.
Yes.
But I am praying for short a passover, my lord. Is engaged.
Passover.
Great.
22.
But I am for the respondent.
Your Lordship, I
22
appeal
and
on behalf of the appel. 22 and 23 are my appeals, arising out of an order dated 1st November 2017.
Pass it over in the first call. Let us run through the list once. There is not sufficient time. We have another bench at 3 o'clock.
3 o'clock.
So we'll rise in 10 minutes.
24. 24. 25.
24, 25, your lordship. In 24, we are for the defendant. In 25, we are for the petitioner. My lord, we informed my lord on the last occasion the parties are trying to reach a settlement. My lord, a draft has also been shared between the parties. If my lord could just grant us some more time to arrive.
How much more time?
3 weeks, your lordship.
3 weeks. পুজোই এসে গেল। পুজো ঠিক আগে রাখি। 24 না
24 and 25, my lord.
24 and 25 একই অর্ডার হবে আলাদা করে। Learned advocates for the parties jointly say that the talks of settlement have progressed substantially. Stop. Draft terms of settlement have 24, 25. And phonographic or TV today দুটোই so settlement have already been prepared. Paragraph as requested.
We are not jointly. For 24. We're appearing for the same party, my lord. 24 we are for the defendant, and for 25 we are for the petitioner. The other side is not here.
Oh, I see. Joint fund bolte hobe na. Learned 24 is who is appearing? You.
We are appearing for the defendant in 24, my lord, and in 25 we are appearing for the petitioner.
Oh, both of you?
Yes, my lord.
Oh. 24, the petitioner is not represented in 24. Stop. Learned advocate for the respondents says that the talks of settlement between the parties have progressed substantially. Stop. As paragraph, as requested by learned advocate, comma, let this matter stand adjourned and be listed again on September 24.
Pledge your lordship.
Same next hobe. The respondents are not represented. Learned advocate for the petitioner bole ja same jinish. You are for you are TV today?
Yes, my lord.
Very good. বুঝে গেছো তো?
Right.
Sir, I am for the appellant led by Mr. Deepak Kollatka. I'm led by Mr. Deepak Kollatka. My lord, can this matter be fixed on 10th September, my lordship? Because my lord, we have served the copy to the other side on several occasions, but due to insufficient address, this has been returned, my lord.
On the request of learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on September 10.
Grateful, lordship.
27. I'm for the respondent, your lordship. Respondent 3 and 4, your lordship.
Who is for the appellant? 27.
I'm for the appellant.
Lordship, I'm led by Mr. Devdut Mukherjee, your lordship. I'm praying for a short passover, your lordship. He's on his way here.
Pass it over.
Grateful.
28. 29. 30. 31. 32.
This is my appeal, my lord. If the lordship is passing it over, I would request your lordship to keep it next Wednesday, my lord. This week there's some difficulty.
Next Wednesday.
Next Wednesday, my lord. Grateful, my lord. Deeply.
33. 34. 35. 36.
36, madam, for the appellant, lord.
I'm for the respondent.
Next.
37.
Possible.
My lord, I'm being led by Mr. Rudrajit Sarkar in this matter. My lord, he's not in court today. If my lord could just give me an adjournment today, my lord.
For adjournment till?
Till, my lord, a week.
On the prayer made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on Shamner Budhvar. No, protocol.
Lordship, I have
8, my lord, Mr. Shokushai Chaudhary was to give his rejoinder, or possibly, my lord, this was argued. There's a S. J. Erickson matter regarding one of the commissioner's report. We succeeded. We are the defendant before the.
Juice Gully.
No, this is not Juice.
It's not Juice Gully.
It's not Juice Gully.
The four deeds.
Yes.
Four deeds. Yes.
This was heard by, my lord, the other bench. Possibly it has to be
Reheard.
My lord. Then Mr. Jishnu Chaudhary is the. And yes, she's there.
We have to hear it afresh, argue it afresh. This bench didn't hear it.
This bench.
Very well, my lord. I'm led by Mr. Chaudhary, my lord. Kindly keeps it on any day, my lord.
Any day is today? Next Wednesday. Next Wednesday.
Grateful.
Even just
39 and 40. 41.
Your Lordship, I'm for the appellant. I'm being led by Shobhushachi Chaudhary, Your Lordship. Short pass over, Your Lordship.
How short?
I know Your Lordship has another bench from 3 p.m.
Oh, you know that. You study the list well.
His way I've called him, Your Lordship.
Not today, not today.
42. 43 and 44.
44, my lord, I am paying for not today, my lord.
Not today.
My-
Not today.
Grateful.
45. 46.
I appear for the respondent.
47.
Sure.
48. 49. 50.
Lordship, I am for the appellant in this matter, Lordship. Lordship, substantial hearing has been taken place. Lordship, if the matter can be taken after vacation, Lordship.
After vacation, yes. Who is arguing the matter?
We are arguing, Mr. Chakravarti was arguing the matter.
Yes. On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed immediately after the puja vacation. October? হ্যাঁ যেদিন খুলছে কোড দিয়ে দেবে সেদিন।
52.
You wanted it after the puja vacation, no? Or Christmas vacation?
Only after the puja vacation.
Sure. Or the next summer vacation?
No, Lordship, not the summer vacation. 52, Your Lordship, I am for the respondent, Your Lordship. For the state, Your Lordship.
Crossover?
53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 7 and 8. 9. 70. 71. 72. 73. 24. 55.
I'm for the risk. This was not once dismissed for default in their absence. Not any.
76. 77. 28. 29.
My lord, I'm led by Mr. Haradhan Banerjee, appearing in this on behalf of the petitioner, my lord. I'm praying for the 3-week adjournment, my lord, due to his health issue, my lord.
Will 3 weeks be sufficient?
My lord, after vacation.
After vacation?
Yes, my lord.
On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed after the puja vacation.
80. 81. 83. 84. 85.
My lord, I'm praying for not today in item 84.
The appellant?
Yes.
Not today.
86, 7, 8, 89 to 93, 94, 95, 96, 97, 98,
My lord, in 98, I am appearing on behalf of the respondent, my lord.
Mr. Ranjan Bachawat was appearing. Yes, we remember. He had started the matter.
My lord, can it be taken up? Can it be, my lord, slightly higher up on, my lord, next Wednesday? I'll tell your lordship the whole difficulty, my lord. 12A leave was revoked. I am for the respondent. But they are, my lord, in the before the, my lord, suit court, my lord, they are saying we have not filed written statement, so the suit has to proceed.
Make it the number 1, especially assigned. First item under this heading.
I am obliged.
But please inform the other side.
Definitely.
Otherwise, they'll be taken by surprise.
Definitely.
$99, 100, 101,
100, my lord, not today.
Not today.
102,
I'm sorry.
My lord, so far as item number 50 is concerned, my lord, both the sides are here, my lord. Your lord, the matter has been posted after vacation, my lord. If a date may be fixed, my lord.
24th.
24th. 24th of October.
Item 1 is to
I appeal for the appellant, my lord. Hearing was concluded, only it was kept for filing our written notes of argument.
Written notes of argument. Written notes of argument filed on behalf of the appellant be kept with the records. Paragraph. Hearing is concluded. Stop. Judgment is reserved. এটা ওই না এটা আমি করেছি was substantially heard by another bench. এটা
Public.
number 3.
Somebody told us today there's a note in the list we haven't seen that with change of determination, part heard will get cancelled.
No, that's been altered.
Sure.
Yes, yes. And
otherwise, this
there is
entire thing will be an exercise in futility.
There is also a subsequent note, Lord, which said that part heard matters can be taken up only on Fridays after 3. There was a note to that extent as well. That has also gone.
Achha.
So there is no problem.
And you're quite sure about that?
Yes, yes. Because this was a point I had taken in a part heard matter before Justice Ajay Mukherjee. His Lordship then told me that this is what it is.
When we were told this thing today, I was elated.
Your Lordship knows the facts more than your Lordships know this fact more than anybody.
Well, the only difficulty which occurs is, well, in an arbitration proceeding, well, the proceeding initial, or commenced, sometimes possibly, in 1993, 94. Ultimately, 34, etc., everything, concluded in, or 34, that was
3033.
3033, that ultimately it happened, sometimes in 2012-13. Several appeal, etc., etc. Then, an order was passed in execution. In the execution, an order was passed. Thereafter, the order said that something has to be done within a particular time. Could not be done. So another application was required to be made in that execution for extension of time. That application was heard by one bench for 6 days, by another bench for 4 days, and by third bench for 6 days. The judgment debtor was obviously dragging or trying to drag. This is the difficulty of not making part heard.
Anyway, this is part heard. Let us hear.
Now, on the earlier occasion, I was placing or I was proceeding on the basis of a list of dates, if your Lordships are pleased to look into that.
This is your list of dates.
Yes, yes, yes. But if your lordship say please to come to my lord, serial number 30, my lord. 30. May, my lord, 2024. Lordship should find immediately after passing of the order dated 6 May 2024, my lord, which is just before, my lord, this date. By the Honorable Supreme Court, HITCO filed an application under Order 11, Rule 5 for disclosure of additional documents. Now, pausing here for a moment, my lord, kindly come to, my lord, 4 lines from just above that. The Supreme Court's order has been quoted, my lord, in bold, the last part of it. Thus, we direct the said court to make an endeavor to dispose of this suit within a period of 9 months from today. Now, this order was passed on 6th of May. 9 months time, my lord, was given by the Honorable Supreme Court to dispose of the suit. Then, my lord, this application was made under Order 11, Rule 5. Then, kindly come to that. After that, upon hearing by an order dated 13th May 2024, the Learned Commercial Court dismissed the application, inter alia stating the reasons. Number 1, HITCO has remained silent since 30th July 2022 till 4th August 2023 in filing the said application at the time of the case management hearing. And 2, HITCO is unnecessarily dragging the suit which is still pending since 4th September 2020 after being transferred to the Learned Commercial Court. The Learned Commercial Court passed order for showing cause as to why the suit shall not be dismissed for default. Being aggrieved by the said order, dated 13th May 2024, passed by the Learned Commercial Court, HITCO filed revisional application being CO number such and such before this Honorable Court. Upon hearing, the Honorable High Court was also of the view that HITCO has been dragging the suit since 2020. The Honorable High Court directed HITCO to file the show cause as to why the suit shall not be dismissed for default and directed the Learned Commercial Court to hear out the application filed under Order 11. HITCO filed reply. Then, my lord, objection was filed. Then kindly come to serial number 37. August 2024. By judgment and order dated 14th August 2024, the show cause was allowed by the Learned Commercial Court. The Learned, kindly come to this order, my lord. This is at page 51 of the supplementary paper book, which was filed. Ojoy Gaggarer দেওয়া পেপার বই আছে দেখ হ্যাঁ অজয় কাকারের তো
Are you likely to conclude today?
I'll try to. I was told that, my lord, a timeline has been given that it has to be concluded today.
Who has given the timeline?
Why?
Supreme Court?
No. My lord, possibly when, my lord, this matter was...
No, because it's very difficult for us to assemble. That is why.
But you're very unlikely, Mr. Chaudhary will not can dictate.
We'll give you another date what to do after Mr. Mitra concludes.
So write a date like that,
No. Yeah, you should go to the way.
What date we get? Oh my God. Why you always running after Mama and not doing matters?
Outside the courtroom, you can even bite him. We don't mind.
It will leave a bad taste.
Yes, literally.
The bad taste of the meat or the person eating. That's a...
হ্যাঁ ওইটা যেটা দেখালেন Kindly come to page 51. The order starts at page 51. Kindly come to page 54. The penultimate paragraph. There is no justifiable reason in this case record as to why the case could not be proceeded with. The grounds assigned in the show cause petition are not tenable, and the said reply to show cause should be rejected and the suit should be dismissed without hearing the same on merits. The learned advocate for the defendant has, however, referred to matters of record regarding such and such. Considering the facts of the omitting that, my lord, kindly come towards the bottom of that page. My lord, about 6-7 lines from the bottom of that page. A sentence starting with however. However, there has never been any stay in the suit, and the case record of the court has proceeded through the different stages of disclosure and discovery, interrogatories, inspection, admission and denial, the case management hearing, framing of issues, and pursuant thereto, the case was posted for peremptory hearing for as many as 5 days, and it was on the 5th day fixed when the direction of show cause was given to the plaintiff vide order number 46 dated 13th May of this case record. The ground of adjournment assigned in the adjournment petitions during the intervening date dated such and such were multifarious. On 5th October 2023, the plaintiff has stated that it has preferred revisional application against the dismissal of the application under Order 7, Rule 11 of the CPC, which was pending before the High Court and pending for delivery of judgment. The said statement itself is a misconceived one, as the revisional application was preferred by the defendant and not by the plaintiff. In the adjournment petition dated 3rd February 2024, the plaintiff has contended that it is in the process of gathering requisite documents and necessary information in order to prepare the evidence, and as such it is not in a position to conduct the matter on that date. In the petition dated 20th March 2024, the same adjournment petition dated 3rd February 2024 has been filed as a replica, just with a change of date. The grounds assigned in the several adjournment petitions show how lightly the plaintiff has taken the case. Date after date has been fixed in this case record, and the parties had permitted the case to roll up to the peremptory hearing stage, and after reaching the peremptory hearing stage, the plaintiff filed repeated petitions saying that the process of collecting documents is still going on. This implies that the plaintiff has made the process of collection of documents a never-ending one without caring for the procedural norms of a case before the commercial court. The plaintiff has referred to 61 writ petitions before the Honorable High Court and has alleged that numerous documents referred to in the judgment of the Honorable High Court with the order dated 13th May 2015 passed by the Honorable Judge have bearing in the instant case, as the instant case involves the question of validity, impropriety of the allotment of land of the defendant made under the chairman's discretionary quota. It appears that whether the said documents have any relevance to the present context is a question of fact. It is for the plaintiff to assert to prove that the said 61 writ petitions have any nexus or relevance in the present case. Even if for argument's sake it is assumed that the said documents have bearing upon the instant case, it is obvious that the court cannot gauge the said facts, if any, on its own. There has been no reference to the said writ petitions or the documents referred to in the judgment passed by the Honorable Justice Banerjee Vide's or Lordship's order dated such and such in the adjournment petitions filed by the plaintiff. The plaintiff had in fact taken it for granted that the suit would not fail irrespective of any vague ground in its adjournment petitions. Just referring to 61 writ petitions in the reply to show cause cannot establish that the said writ applications and the documents related therein have any nexus with the present case. As such, it appears that the plaintiff's conduct is condemnable due to lack of transparency and casual approach in dealing with the procedure of the court. The causes shown are not sufficient. However, the reply to show cause deserves to be allowed and accepted only to honor the direction of the Honorable Court that this court should hear the application under Order 11, Rule 5, read with Section 151 of CPC on merit, and should take steps to comply with the direction of the Honorable Apex Court to complete the hearing of the suit pending before it within 9 months from 6 May 2024. As the suit has to be disposed of on merit, the show cause deserves to be accepted, as otherwise there would be no alternative for the court than to reject the show cause and dismiss the suit without hearing on merits. Now, this was the show cause. Then, my lord, the application was again taken up for hearing. That your lordship should find, my lord, serial number 40. The learned commercial court dismiss the application. I shall place that order. But before that, my lord, I would like to show, my lord, the pleadings in that application, some portions, not in its entirety. And, my lord, the law on, my lord, Order 11, Rule 5. How do you eat the judgment? No. Judgment will refer to it. My lord, kindly, may I first rely on a judgment of the Honorable Supreme Court, my lord, reported in 2021, Volume 13, Supreme Court Cases, page 71. May I, my lord? Well, in fact, my lord, since we were under the impression that, my lord, we have to conclude it, my lord, today, we prepared, my lord, a compilation along with the notes, my lord. May I, my lord? Huh?
I'm glad we gave you that impression. Can we release your other friends?
I will take till 4 about, my lord, maybe till about 4. But after that, তারপরে কিছু আছে নাকি আমাদের কি তো last?
You can start responding today.
We come back on any other day, because I am not there, because I have to leave at 4. And my senior is also not there, my lord. He has to also. So any other day, my lord?
Let us see. Let us see.
Gotcha. Well, let kindly come to page 104 of this compilation. That's, my lord, 2021, volume 13, Supreme Court Cases, page 71. Well, kindly come to page 108. At the bottom of that page. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 6 April 2021, passed by the High Court of Delhi at New Delhi in CM number such and such, by which the High Court has dismissed the said petition preferred by the appellant herein, that is the original plaintiff, and has confirmed the order dated 13th November 2019, passed by the Learned Commercial Court dismissing the application filed by the appellant under Order 7, Rule 14(3) of the Code of Civil Procedure, seeking leave of the court to place additional documents on record. The original plaintiff has preferred the present appeal. Then, my lord, kindly come to paragraph 2. May I, my lord, omit of first few lines. My lord, about, my lord, 8 lines from the bottom of paragraph 2. A sentence starting with as per the provisions.
Yes.
Paragraph 2. As per the provisions of Order 11, Rule 1, applicable to the suits before the Commercial Division of a High Court or a Commercial Court, the plaintiff was required to file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining this suit, along with the plaint, or certain documents including the invoices were not produced along with the plaint, and therefore the appellant herein filed the application under Order 7, Rule 14(3), read with section 151 seeking leave of the court to file additional documents. Then paragraph 3. By order dated 13th November 2019, the Learned Commercial Court dismissed the said application seeking leave of the court to file additional documents filed by the appellant. That thereafter, the defendant filed the written statement on 6 January 2020. As per Order 11, Rule 7, even the defendant was required to file the list of all documents, photocopies of all documents in its power, possession, control, or custody pertaining to the suit, along with the written statement or with its counterclaim, if any. However, some documents were not produced by the defendant along with its written statement, and thereafter, the defendant filed an application under Order 11, Rule 1, Subrule 10 CPC seeking leave of the court to produce additional documents as set out in the said application, which was partly rejected, etc. Then next ballot. Paragraph 4. The respondent here in the original defendant preferred an appeal against the order dated 8th October 2020 before the Delhi High Court. The Delhi High Court, with the order dated 7th December 2020, allowed the said appeal, taking on record all the documents filed by the defendant. That thereafter, the Learned Commercial Court dismissed the interim injunction application. Then paragraph 5. That thereafter, the appellant herein, the original plaintiff, filed CMM number such and such before the Honorable High Court at Delhi, challenging the order dated 13th November 2019, dismissing the application seeking leave of the court to file additional documents filed by the plaintiff. By the impugned judgment and order, the High Court has dismissed the said CM number such and such and has confirmed the order passed by the Learned Commercial Court dismissing the application seeking leave to file additional documents filed by the plaintiff. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, the original plaintiff has preferred the present appeal. Then, my lord, the arguments are, my lord, recorded. Kindly come to page 1131. Paragraph 9. We have heard the Learned Counsel. 9.1. By the impugned judgment and order, the High Court has dismissed the petition confirming the order passed by the Learned Commercial Court dated 13th November 2019, dismissing the application filed by the appellant herein, original plaintiff, seeking leave of the court to place additional documents on record. That by the said application, the plaintiff prayed to permit him to place on record the invoices as mentioned in paragraph 3 of the application, and also certain other additional documents. That the plaintiff stated in the application for leave to place on record additional documents in paragraph 3 and 4 as under. 3. That the accompanying documents along with the present application, in particular invoice dated such and such, could not be filed along with the plaintiff being very old and not in possession of the plaintiff at the time of filing of the plaint. Now the plaintiff has found the same from Shivalik Graphics. Paragraph 4 of the application that the documents other than above named documents could not be filed due to voluminous records pertaining to plaintiff's case could not be filed at the time of filing of the case, but the same are very important for the adjudication of disputes between the parties. The aforesaid application has been dismissed by the Learned Commercial Court, which has been confirmed by the High Court by the impugned order. Then, my lord, kindly turn the page. 9.3, Order 11 is really set out. My lord, kindly come to page 115. Order 11, Rule 1, Subrule 5 at the bottom of that page. The plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody, and not disclosed along with plaint, or with the extended period set out above, save and except by leave of court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint. Yes, and before that, my lord, kindly come to sub-rule 3 also. The plaint shall contain a declaration on oath from the plaintiff that all documents in the power, possession, control, or custody of the plaintiff pertaining to the facts and circumstances of the proceedings initiated by him have been disclosed and copies thereof annexed with the plaint, and the plaintiff does not have any other document in its power, possession, control, or custody. Now, this statement of truth they filed, my lord, subsequently. It may come back to your lordship's mind, it's difficult, that the suit was originally filed, my lord, when the Commercial Code did not come into force. After the Commercial Codes Act came into force, the suit was transferred to the Commercial Division. Thereafter, my lord, this case management steps were taken, hearings took place, and in that this statement of truth was filed. So that was filed in about 2023, whenever it is. I shall give the date. Then, my lord, kindly come to page 117. Just after, my lord, sub-rule 12 is quoted after that at the top or towards the middle. Order 11, Rule 1.3 provides that the plaint shall contain a declaration on oath from the plaintiff that all documents in the power, possession, control, or custody of the plaintiff pertaining to the facts and circumstances of the proceedings initiated by him have been disclosed and copies thereof annexed with the plaint, and the plaintiff does not have other documents in its power, possession, control, or custody. As per the explanation under Order 11, Rule 1.3, a declaration on oath under sub-rule shall be contained in the statement of truth as set out in the appendix. Appendix 1 with respect to the statement of truth reads as under. Then Appendix 1 is set out. The statement of truth was filed on 7th December 2022. That would appear from serial number 21 of the list of dates. Then, my lord, kindly come to page 118. Towards the middle, my lord, just after this quotation ends, therefore, the declaration on oath shall be part of the plaint. The plaintiff has to declare on oath that all documents in his power, his power, possession, control, or custody pertaining to the facts and circumstances of the proceedings initiated by him or it has been disclosed, and the copies thereof annexed with the plaint, and that he does not have any other documents in his power, possession, control, or custody. Therefore, as such, it is mandated by Order 11, Rule 1 for the plaintiff to disclose and produce all the documents in his power, possession, control, or custody pertaining to the facts and circumstances of the proceedings. However, the additional documents can be permitted to be brought on record with the leave of the court as provided in Order 11, Rule 1, Sub-Rule 4. Order 11, Rule 1, Sub-Rule 4 provides that in case of urgent filing, the plaintiff may seek leave to rely on additional documents as part of the above declaration on oath as provided under Order 11, Rule 1.3, and subject to grant of such leave by court, the plaintiff shall file such additional documents in court within 30 days of filing the suit, along with a declaration on oath that the plaintiff has produced all documents in its power, possession, control, or custody pertaining to the facts and circumstances of the proceedings initiated by the plaintiff, and the plaintiff does not have any other document in its power, possession, control, or custody. Then 9.5. Order 11, Rule 1, Sub-Rule 5 further provides that the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with plaint or within the extended period set out above, save and except by leave of the court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint. Therefore, on combined reading of Order 11, Rule 1, Sub-Rule 4, read with Order 11, Rule 1, Sub-Rule 5, it emerges that 1. In case of urgent filing, the plaintiff may seek leave to rely on additional documents. 2. Within 30 days of filing of the suit. 3. Making out a reasonable cause for non-disclosure along with the plaint. Therefore, a further 30 days time is provided to the plaintiff to place on record or file such additional documents in court, and a declaration on oath is required to be filed by the plaintiff as was required as per the Order 11, Rule 1, Sub-Rule 3. If for any reasonable cause for non-disclosure along with the plaint, the documents which were in the plaintiff's custody, possession, control or custody and not disclosed along with the plaint. Therefore, the plaintiff has to satisfy and establish a reasonable cause for non-disclosure along with plaint. Disclosure of the document along with the plaint shall not be applicable if it is averred that it is the case of the plaintiff that those documents have been found subsequently and in fact were not in the plaintiff's power, possession, control or custody at the time when the plaint was filed. Therefore, Order 11, Rule 1, Sub-Rule 4 and Order 11, Rule 1, Sub-Rule 5 applicable to commercial suit shall be applicable only with respect to the documents which were in plaintiff's power, possession, control or custody and not disclosed along with the plaint. Therefore, the rigor of the establishing by reasonable cause in non-disclosure along with the plaint may not arise in the case where the additional documents sought to be produced relied upon are discovered subsequent to the filing of the plaint. Having considered the statutory provisions in detail, the order passed by the learned commercial court confirmed by the High Court rejecting the application of the plaintiff for leave to rely on the additional document is required to be tested, etc. Now, my lord, this is the principle on which the application are to be dealt with. Then it goes into the matter, my lord. It allowed a part of the documents which were not in the custody of the plaintiff, and my lord, they did not allow the documents which were in the custody of the plaintiff. And my lord, second part which was disallowed was their allegation was that these voluminous records could not be disclosed along with the plaint. Now, the same, my lord, has been followed in the next judgment. Of course, my lord, it's a single bench judgment of this honorable court at page 123 in the matter of Fixopan. It really does not say something new, my lord. So, and it considered Sudhir Kumar and my lord proceeded. Only one paragraph, my lord, kindly come to paragraph 12. The Honorable Bombay High Court in Khanna Rayon Industries in paragraph 31 observed as follows. The Supreme Court in the case of Sudhir Kumar, that is the case I cited right now, has referred to the strict requirement of Order 11, Rule 1, Sub-Rule 5 of the CPC in the context of commercial suits. And after referring to such strict requirement, the Supreme Court held in the said case that the plaintiff therein could not be permitted to contend that it has reasonable cause for non-disclosure, non-filing of the documents along with the plaint on the ground that the documents were voluminous. In a series of judgments that is such and such, the Delhi High Court has applied the rigor of Order 11, Rule 1, Sub-Rule 5 of the CPC in commercial suits in various circumstances to examine as to whether the plaintiffs therein had made out reasonable cause for non-disclosure of documents with the plaint. It was found that when the plaintiff failed to place on record proper reasons and reasonable cause permitting additional documents to be placed on record at any stage, although they were in the power, possession, control or custody of the plaintiff, would make a complete mockery of Order 11 of the CPC and made applicable to commercial suits. It was found that reasonable cause would have to be specifically pleaded, and only when good cause was made out that the plaintiff could be permitted to place on record such documents at a later stage. It was held in the said judgment that leniency in such matters would run counter to the very object and purpose for which such amendment in the CPC were introduced by the Commercial Courts Act. Now, this is the law, my lord. In this background, kindly, my lord, take up their application, my lord, which was made under Order 11, Rule 1. My lord, that is, my lord, Volume 5, page 639.
সেটা আমি সুপারস্টার মার্ক করে সকল ফেল করলো সে বাজেট পেয়েছে তখনই একটা রিজন দিল এই দুটো পুরো কন্ট্রাডিকশন
Kindly come to page 639. Kindly come to page 640, paragraph 3. This is the application which they made. Paragraph 3. After the suit has been transferred in this learned court and has been renumbered as a commercial suit, the plaintiff has filed a list of documents in accordance with Order 11, Rule 1, Sub-Rule 2 of the Code of Civil Procedure, by disclosing therein only the documents which form part of the disclosures to the plaintiff of the application filed by the plaintiff under Order 39, Rule 1 and 2 of the Code of Civil Procedure. Next, the present suit has now proceeded to the peremptory hearing stage. Next part is very important, my lord. Though no case management hearing has taken place. This is a blatant false statement. Kindly come to page 710. Page 710 is there, my lord. Show cause notice reply. But kindly come to page 715. Top, paragraph 13. The plaintiff had thus disclosed the said documents as its disclosure when the case management hearing had taken place, when the advocate on record of the plaintiff had only appeared and the senior counsel were not engaged on behalf of the plaintiff. So case management hearing took place. As my lord mentioned in their show cause notice or reply to the show cause notice. Yeah, form করেছে দেখো no এই application and the same person has affirmed both the application as well as reply to the show cause notice. Parthopratim Mollik.
সেই স্টেটমেন্ট অফ ট্রুথ অ্যাফার্ম করেছে
And he himself has affirmed the statement of truth. Now, may I kindly come back to 640. The present suit has now proceeded in the paragraph 4, though no case management hearing has taken place, despite an order to that effect being passed on 1st March 2023. On the next date fixed, that is on 12th April 2023, the defendant filed an affidavit of admission denial and list of documents suggested issues, a subsequent date was fixed for framing of issues. This would be evident from the order sheet in the present suit. Kindly omit paragraph 5. Kindly come to paragraph 6. Thereafter, issues have been framed and the case has been fixed for peremptory hearing. Next part is important. It is at this juncture that the concerned officers of the plaintiff had started preparing the evidence on affidavit with the advocates when several documents relating to the present case and the larger issue involved in respect of allotment of plot under the chairman's discretionary quota at Newtown, which has a huge bearing on the present suit, had surfaced, which did not form part of the list of disclosures filed by the plaintiff in their custody, documents in their custody. Then paragraph 7. It would be evident from the disclosure of the defendant that the defendant has sought to rely upon a judgment of the Honorable High Court at Calcutta in the case of Govinder Prasad Ladda and others versus State of West Bengal, where 61 writ petitions challenging cancellation of allotment of plots of land allotted under the chairman's discretionary quota were dismissed by a common judgment and order passed by the Honorable Justice so-and-so. In the said judgment, there is reference to several illegalities perpetrated to obtain illegal allotment of plots under chairman's discretionary quota and the several illegalities which the erstwhile management of the plaintiff had committed, which warranted mass cancellation of the said allotments. For the effective adjudication of the instant suit, the said documents which already find reference in the said judgment and order which has been relied upon by the defendant are required to be produced at the said, as the said documents would be required by this learned court to completely and effectively adjudicate the disputes between the parties in the present suit and to render substantial justice with regard to the allotment of plot of land in favor of the defendant under the chairman's quota. Then paragraph 10, the plaintiff seeks to disclose the following further documents in the present suit over and above the disclosure already made by the plaintiff. A, the shareholding pattern of the plaintiff to show that the plaintiff is a wholly owned state of West Bengal government undertaking and the plaintiff is a government company. This ought to have been in the records. B, the minutes of the first meeting of the board of directors of WB Hitco held on 21st March 1999. This was again in the records. C, minutes of the fourth board meeting of WD Hitco held on 2nd February 2000 where a decision was taken regarding disposal of allotment, etc. Again, should be in their records. D, an advertisement published on 28 June 2001 inviting applications for allotment of residential plots under the chairman's discretionary quota. E, a further advertisement published on 30th August 2003 inviting application for residential plots referring to the guidelines within such and such, and a further advertisement published on 8th August 2005 inviting application for allotment of residential plots under chairman's discretionary quota. F, a government order notification dated 13th October 2003. G, advertisement dated 9th September 2006 inviting application for residential plot. H, minutes of the 37th board meeting of WB Hitco held on 29th December 2006 wherein agenda item number 17 was approved creating chairman's discretionary quota. I, guidelines for allotment of non-residential plot under the chairman's discretionary quota was finalized by the officers of special duty to the chairman on 3rd October 2007, which was approved by the erstwhile chairman on 5th October 2007. Advertisement dated 12th October 2007 inviting application for non-residential plots referring to guidelines within 31st December 2007. Advertisement dated 29th February 2008 inviting applications for non-residential plot. L, minutes of an alleged meeting of the screening committee purportedly convened on 24th May 2007 for examining applications. M, minutes of alleged meeting of the screening committee of 28th April 2008. N, minutes of 59th board meeting of Hitco held on 28th February 2011. O, Minutes of a meeting of a Parpated committee at 6 p.m. on 28th February 2011. P. Notification of the Election Commission of India dated 1st March. All these documents admittedly were in their custody. Suit was filed in 2014. The statement of truth was filed in 2022. And there is no explanation as to why these were not produced. Now, interestingly, kindly come to the show cause notice reply. হ্যাঁ 303 আর 710 বোধহয় কাছে নেই।
That is 715.
Yes, my lord.
একই তো আমার এখানে এক জায়গায় 303 লেখা, এখানে আরেক জায়গায়
সাপ্লিমেন্টারি 303 থেকে দেখাচ্ছিলেন এখনই। সাপ্লিমেন্টারি 303-এও আছে সেম রিপ্লাই। প্যারা 13 আপনি ওখান থেকে দেখালেন, প্যারা 13 308-এ আছে। 14 আর 15 তিনটে।
সরি, সন্দীপ দাস সত্য বার করছে।
হ্যাঁ কি
Kindly come back to page 7101, my lord. 710 থেকে দেখি আগেরটা দেখি। Kindly come back to 710, my lord, the reply to the show cause notice.
710?
Yes.
Yes.
It's there at page 303 also, but kindly come to 710. It's in the same volume. Kindly come to page 715. I placed paragraph 13. Kindly come to paragraph 15. Or paragraph 14. The advocate on record of the plaintiff was under a mistaken impression that the plaintiff needs to disclose only those documents which were annexed to the plaint. However, the facts of the matter are such that there are several other documents which the plaintiff needs to disclose to enable this learned court to completely and effectively adjudicate upon the disputes between the parties. It is in view of this miscommunication with the advocate on record of the plaintiff and the senior counsel engaged in the matter that the plaintiff had merely disclosed only those documents which were annexed with the plaint and had not pointed out in course of the case management hearing that the plaintiff is required to disclose further documents. It is in these circumstances that based on the documents disclosed in the plaint, the defendant had completed its admission and denial. Thereafter, the plaintiff had requested the senior counsel looking after the matter before the Honorable High Court at Calcutta at the time of contesting CO number such and such to prepare the evidence on affidavit of the plaintiff. It is at this juncture that gradually several documents were unearthed which are extremely germane and had bearing on the present case. The issue in the present suit is on the validity and propriety of the allotment of the land of the defendant made under the chairman's discretionary quota. The allotment cannot be looked into in isolation, and several other documents, the procedure for the same, the decision-making process, or the lack thereof, and the illegalities in the same are required to be brought to the notice of this learned court, which is of utmost importance. Such documents are extremely voluminous and inasmuch as the allotment concerned different allottees, different office files of the plaintiff are required to be consulted, and relevant documents are required to be culled out. Moreover, the relevant officers of the plaintiff at the time of the allotment are no longer in the service of the plaintiff. That apart, most of the officers of the plaintiff who had assisted the counsel of the plaintiff during the hearing of the 61 writ petitions before the Honorable High Court at Calcutta, which culminated into passing of the judgment and order dated 13th May 2015, passed by the Honorable Justice Banerjee, as his lordship then was, and reported in such and such, have also retired. No particulars, nothing. Thus, it is a Herculean task for the subsequent inductees in the plaintiff to cull out the numerous documents referred to in the said judgment and provide the same to the counsel for the plaintiff to prepare the evidence on record. Mr. Chatterjee points out, my lord, that the counsel continued to be the same. 21. It is in these circumstances that a considerable time has got consumed while preparing the evidence on affidavit, for which the plaintiff had to seek orders of adjournment for filing of its evidence on affidavit. Such adjournments sought were for just cause and for reasons beyond the control of the plaintiff. Now, this is the cause shown here, completely different to the petition.
Page 112, para 8.
812,
volume 6.
812. Now, kindly once come to volume 6. Kindly once come to volume 6. Page 816, there rejoinder.
812.
812. Starts at 810, the volume. Kindly come to page 812, paragraph 8. 4 lines from the bottom of that page. The case manager, lordship's got that.
This is rejoinder
to this application, my lord.
আমার অপোজিশনের
Order 11, rule, my lord, 1 application. Reply to my objection.
Yes.
Paragraph 8, 4 lines from the bottom of page 812. The case management hearing had also taken place, and the plaintiff was under a bona fide impression that in view of the judgment of the Honorable Justice such and such in Govind Prasad Ladda, the writ petition, 61 writ petitions, concerning cancellation of allotment of plots of land under the chairman's discretionary quota, which is similar to that of the present case, which has been upheld by the division bench of the division bench, which has been upheld till the Honorable Supreme Court of India, the plaintiff would not be required to disclose any further documents, as the judgment would clearly show the fraudulent nature of the allotment of the plaintiff. However, the defendant preferred a special petition, being SLP such and such, whereby an order dated 23rd January 2023 of the Honorable Supreme Court of India was pleased to dispose of the said special petition, with an observation that the suit would be determined on merit dehotes any observation made against the petitioner. It deserves mention that during the juncture, the civil revisional application assailing the dismissal of Order 7 Rule 11 application was being heard, out of which ultimately travelled up to the Honorable Supreme Court and was dismissed by the order dated. It is thereafter that the plaintiff has filed the instant application praying for disclosing additional documents, which are all referred to in the judgment of the Honorable Justice such and such, which are extremely germane for the purpose of adjudication of the present suit. Thus, the instant application is being necessitated and the documents are not only relevant but are extremely germane for the purpose of adjudicating upon the facts in issue in the present suit. Inasmuch as the documents are voluminous and are scattered across various allotment files and pertain to matters which got disposed of way back in 2015, it took considerable time for the present officials of the plaintiff, most of whom were not in the service of the plaintiff as on 2015, to call out the same and make over the same to the advocates of the plaintiff. It is in these circumstances that the plaintiff was constrained to take adjournments. So three pleadings, my lord, different. And my lord, I have shown, my lord, the
same pleadings would become boring.
Yes, that's true. That's true. And my lord, the courts have said, my lord, I have shown the judgments, my lord, that voluminous records, my lord, is no defense. Or my lord, no ground to allow this application. Now kindly, my lord, come to the order passed in this application, my lord, on 3rd October, my lord. That is, my lord, at page 62 of the supplementary paper book, my paper book. No, ekhane. Volume 1.
The order dismissing the plaintiff's order 11.
Yes.
Supplementary.
What is it?
এটা নিয়ে নাও।
আচ্ছা। No. Kindly come to page 68. ওই অজয় গগ্গরের পেপার বইটা। Page 68, the last paragraph. The plaintiff has filed the instant application under Order 11, Rule 5 of the CPC seeking leave to disclose additional documents after about 10 years since the institution of the suit. The plaintiff has not prayed for amendment of the plaint and yet it has sought to disclose additional documents which in essence would alter the original cause of action of the plaintiff. Now, my lord, pausing here for a moment, my lord, I remember one submission made before your lordships that, my lord, the documents are not required to be pleaded. Absolutely. Documents are not required to be pleaded, but the case has to be made out. And that case was not made out in the plaint. The disclosure of documents, my lord, would not have supported the plaint case. Such belated petition under Order 11, Rule 5 of the CPC is harassing for the defendant. When the plaintiff filed the statement of truth on 6 December 2022 before the court, it has shown that all documents in his power, possession, control or custody pertaining to the facts and circumstances of the proceedings initiated by itself have been disclosed and copies of the same have been filed before the court along with the plaint, and that it does not have any other document in its power, possession, control or custody. The additional documents which the plaintiff is now seeking to introduce were all along within the power, possession, control or custody. The plaintiff has relied upon the said documents in course of hearing of the writ petition and in the appellate proceedings arising therefrom. In the show cause filed by the plaintiff, it has made several contentions. Among such contentions, one ground is that the learned advocate on record for the plaintiff was under a mistaken impression that the plaintiff had to disclose only those documents which were annexed to the plaint. But several other documents are necessary for effective adjudication of the suit. Then, my lord, kindly come to page 71. Third paragraph. The plaintiff successfully dragged the suit over the years. The defendant has urged other grounds as well in the written objection at hand and has also contended that Order 11 Rule 7 CPC applicable to commercial court has made it clear that Order 7 Rule 14 CPC has no application to the commercial suit. As such, there is no scope of producing or relying upon documents by the plaintiff as per the said provisions of CPC at a later stage, even with the leave of the court. Accordingly, the defendant has prayed for rejection of the instant application. Considering the facts and circumstances of the suit, the plaintiff along with annexures filed thereto, the materials on record, the instant application under Order 11 Rule 5 of the CPC, the affidavit in opposition and the rejoinder they filed thereto, the submissions of the learned advocate for both the sides, the written notes, etc. The application is next paragraph. The application is under Order 11 Rule 5 read with Section 151 of CPC. The provisions of Order 11 Rule 1, Sub-Rule 4 and 5 have close bearing on each other. The said provisions run thus, well, those are quoted. Then next, on plain reading of the said section, it appears that the time to file additional documents in a commercial suit before the commercial court is primarily within 30 days of the date of filing of the suit. But for the same also, the plaintiff is required to seek leave of the court to file additional documents in case of urgent filing. When the said additional documents are filed with the leave of the court within the said 30 days of filing of the suit, the plaintiff has to swear a declaration on oath stating that it has produced all its documents in its power, possession, control, or custody pertaining to the facts and circumstances of the proceeding initiated by the plaintiff, and the plaintiff does not have any other document in his power, possession, control, or custody. Order 11 Rule 1 Sub-Rule 5 of the CPC starts with a negative covenant that the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with the plaint or within the extended period set out above, that is the extended period of 30 days from the date of filing, save and except by the leave of the court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint. In the instant suit, the additional documents relating to several writ petitions filed in the year 2012, 13, 14 were well within the knowledge of the plaintiff. In fact, the judgment of the Honorable Justice Banerjee referred to above passed on 13th May 2015. At that time, the instant suit was not a commercial suit and was just pending in the court of the learned civil judge at Barashat as a regular suit. The documents involved in the said writ petition were not unknown to the plaintiff, and as mentioned by the learned advocate for the defendant in one of the writ petitions, the plaintiff has filed the affidavit in opposition affirmed on 16th March 2015, stating that the defendant did not fall in a similar circumstances as that of those writ petitioners whose allotments were also granted from the chairman's discretionary quota. As such, it appears that there is no overwhelming fact for certainly dragging the documents relating to the said 61 writ petitions and the details of meetings, minutes, advertisement, and notification therein as additional documents of this suit. The instant suit has come up before this court for disposal as a transferred suit from the court of the learned civil judge. Section 15, subsection 3 of the Commercial Courts Act provides that when any suit or application relating to commercial dispute of specified value is transferred to a commercial court, the provisions of the said act shall apply to those procedures that were not completed at the time of transfer. It appears that the instant suit which was filed on 27th October 2014 before the civil court was transferred to this court with the order dated 12th July 2019, and the case record was received by this court on 4th September 2020. But till that date, no procedure of the suit was completed, not even the service of summons upon the defendant. It shows the dilatory conduct of the plaintiff, having led the suit to proceed without any effective development from 2014 to 2020. And this also indicates that, in fact, all the procedures of the Commercial Courts Act 2015 and amended procedure of CPC applicable to commercial courts were applicable to the instant suit. But even after the transfer of this court to this court, the plaintiff continued in the same vein with its dilatory attitude. The plaintiff was directed to file show cause with the order dated 9th March 2021. It submitted the show cause which was accepted by order dated 26 March 2021. and thereafter the plaintiff remained busy in several adjournments and contesting application under Order 7 Rule 11 of CPC, which was filed by the defendant on 23rd July 2021. The said application filed by the defendant was rejected by this court with the order dated 7 June 2022, and thereafter both the sides had been contesting CO number such and such. Kindly come to the next paragraph. The case record reveals that the suit was duly posted for disclosure and discovery, interrogatories, inspection and admission and denial, as well as the case management hearing on different dates, but neither party availed the same. The carriage of the suit lies upon the plaintiff, but the plaintiff has been negligent all along to pursue the paraphernalia and the special procedure applicable to commercial suits in respect of the instant suit. May I kindly omit this next part? Kindly come to the last paragraph. In fact, in this negligent manner, the plaintiff has passed 10 years from the date of filing of the suit, and it has no hesitation to state that they became serious about the procedure of this suit only after the rejection order was passed by the Honorable Apex Court video order dated such and such. They have not availed the opportunity of inspection, discovery, admission and denial, as well as case management hearing, which are the specialties, etc. Then, my lord, the application was dismissed ultimately. And my lord, the matter was fixed for peremptory hearing on 12th of November 2024. Now, my lord, kindly come to page 80. The order ends at page 78. Kindly come to page 80. Kindly come to page 80. Today is fixed for peremptory hearing. The learned advocate for the plaintiff appears and files Hajira along with an adjournment petition. Page 80. Yes. Then, my lord, kindly see the penultimate paragraph fixed 28th November and 29th November and 30th November as consecutive days for evidence. Then kindly come to the next paragraph, next page, page 81. The learned advocate for the plaintiff appears and files Hajira. The learned advocate for the defendant appears and files Hajira along with an application under Order 19, Rule 5, read with Section 151 of the CPC.
What is that?
This is for, my lord, reduction of, my lord, the evidence filed, because, my lord, the evidence what they tried to do, I have in my notes, my lord, given a comparative statement. My lord, what they tried to do was, what they could not incorporate by way of the documents, they tried to incorporate by way of averment in the affidavit.
Affidavit of evidence.
Yes. The entire letter, entire documents were sought to be set out in the paragraphs without being able to disclose the documents. So that was challenged. It's at page 47 of the notes, the comparison. Yes. Then kindly come to, my lord, towards the bottom of that page, page 81. The written objection against the application under Order 19, Rule 5, read with Section 151 is to be filed by the plaintiff on 5th December 2024. Reply, if any, by 10th December. Well, kindly come to the next page. Today is fixed for filing written objection by the plaintiff against the application under Order 19, Rule 5. No step is taken by the plaintiff in compliance of the earlier order. That is 5th December 2024. Then kindly come to page 83, 12th December 2024. Today is fixed for hearing of the application and dated 28th November 2024 in respect of the application under Order 19, Rule 5, read with Section 151 of CPC. The learned advocate for the plaintiff, etc. Then it transpires from the case record that by an order dated 28th November 2024, this court directed the plaintiff to file written objection by 5th December 2024 in respect of the application under Order 19 Rule 5 CPC, but till date the same is not filed before this court. However, the learned advocate for the defendant submits that the written objection has been served upon the defendant on 6th December. Let affidavit in reply be filed. Fixed 17th December. Now kindly come to the next page. My lord, page 84, it is taken up for hearing. Then, my lord, kindly come to page 91 directly. Kindly come to page 91, the order dated 18th January 2025. The instant application under Order 19, Rule 5, read with Section 151, filed on behalf of the defendant, is taken up for hearing for passing necessary order. Kindly come to, my lord, page 108. Penultimate paragraph at page 108. The plaintiff has deliberately prolonged the proceeding over the years. After the rejection of the plaintiff's application under Order 11, Rule 5, read with Section 151 by Order number 59 dated 3rd October 2024, the next date was fixed for peremptory hearing. However, the plaintiff had failed to file the affidavit in chief and had instead sought an adjournment on that occasion. On the next hearing date, the plaintiff again sought an adjournment. The plaintiff has repeatedly sought adjournments at every hearing, thereby unnecessarily delaying the suit. The court has already rejected the plaintiff's application under Order 11, Rule 5, read with Section 151 of the CPC, and directed that additional documents cannot be disclosed. The plaintiff's conduct in misrepresenting facts and presenting false averments undermines the dignity of the court and seeks to mislead it. This is in direct contradiction to the directive issued by the Honorable Supreme Court of India in specially petition dated such and such, which specifically mandated the disposal of the suit within a period of 9 months from the date of the order. The plaintiff's approach, characterized by such dilatory tactics and negligence, cannot be entertained under any circumstances. Such conduct is detrimental to the expeditious and fair administration of justice, and this court is urged to take note of the same. Hence, the defendants press for an order. Then kindly come to, my lord, page 115. The ordering portion. The application under Order 19, Rule 5, read with Section 151 of CPC filed on behalf of defendant is considered and allowed on contest. Subject to redaction, the plaintiff is permitted to rely only on the portions of the examination in chief which are not redacted in the exercise of the discretionary power of this court. The redacted portions are in the following paragraphs. Then, my lord, the paragraphs are mentioned. In fact, my lord, after that, no further affidavit was required to be filed possibly. And kindly come to page 117. The plaintiff is at liberty to file the evidence on affidavit afresh, excluding the redacted portion strictly in terms of this order for the sake of neatness and transparency. Fixed 21st January 2025 for tendering evidence in the redacted version of the evidence on affidavit. In view of the direction passed by the Honorable Apex Court, the parties are to take a note that no further unnecessary adjournment shall be entertained under any circumstances. Now kindly turn the page. Next order, my lord, it was fixed on 21st of January. Kindly come to the next order dated order number 72 dated 21st January. Third paragraph. Or second paragraph. Today is fixed for tendering evidence in the redacted version of the evidence on affidavit on behalf of PW1. The learned advocate for the plaintiff has sought for 48 hours time submitting that he became aware of the order yesterday only at 9 p.m. after it was uploaded in the server. It was not possible for him to inform the client and get the PW1 ready for evidence within such a short period of time. He intends to file a redacted version of the evidence. Considering the volume of the evidence redacted under Order 19, Rule 5, read with Section 151 of CPC, and the time that may be necessary for preparing a fresh evidence after deleting the redacted portion from the affidavit of evidence under such and such, he is praying for time on humanitarian ground. The concerned witness works in the public sector unit and time is needed to get him ready for the evidence, hence the petition. The learned advocate for the defendant raises objection, then kindly come to page 120, second paragraph. The fate of the defendant's application under Order 19, Rule 5, read with Section 151 was visible in the case information system on 18 January 2025 itself. So the plaintiff should have been aware of the order from 18 January 2025 itself. The court did not fix any time limit for filing fresh redacted version of the affidavit on evidence. The witness for the plaintiff should have appeared before the court to tender the evidence which is already on record. Filing a fresh redacted version of the affidavit on evidence does not require additional 48 hours waiting period on this day, given the advancement in computerized systems and technology, which allows for more efficient and immediate process. At least the plaintiff's witness should have been present in court today. Hence, it is ordered that the plaintiff is directed to show cause as to why the evidence of the plaintiff shall not be closed and of this suit shall not be dismissed for non-compliance of court's order dated 18 January, fixed 22nd January 2025. Then kindly turn the page, kindly come to page 122. Order 73 dated 22nd January 2025, page 122. Third paragraph. The learned advocate for the plaintiff files an adjournment petition framed for 2 weeks' time on the ground stated therein. And my lord, the court made it absolutely clear that, my lord, it has to be heard on those days. And kindly come to this order then, my lord, the ordering portion.
On the previous day, the 21st, they had said they want time to file the redacted version.
That was not done.
No, instead, they challenged the order.
Now, their allegation was, my lord, opportunity was not given. That was the main allegation. Now, my lord, with greatest of respect, my lord, if I may ask myself the question, my lord, what further opportunity? From the very beginning, the court was, the court was consistently saying that, look here, I have to conclude the hearing within a particular date. I have to conclude that the hearing has to be concluded as per the Supreme Court direction. My lord, as I possibly submitted this before your lordships also, that, my lord, the option was either comply with the Supreme Court's order or oblige the state government. This was the position. And I will show you, lordship, my lord, the Supreme Court, what, my lord, Supreme Court has said about such type of stands taken by the parties. Supreme Court has deprecated such practice of taking adjournments and delaying proceedings. Then, my lord, 124, the evidence was closed.
Are you likely to conclude today? Possibly not. Let us fix another date.
My lord, but I will not take long, my lord.
Roughly?
At the most half an hour, my lord. Possibly not even that.
Will also require half an hour, my lord.
Yes, on the next date itself.
Yes, my lord.
Do not ask for further time. देखो दाও বই ডেটটা দেখো 16th কি বার? 16th. Same time.
Mr. Chaudhary is in some difficulty, yes.
The 16th he will be in Supreme Court.
Yes, my lord.
In?
Supreme
Why you are on the other side?
শিফট করছে ও তুমিও আচ্ছা
Not against our order. Then we will fix it on the 16th itself. 17th. 17th. Mr. Mitro, Mr. Surojit Nath Mitro, learned senior counsel representing the respondent, resumes his argument but does not conclude. Stop. Paragraph. As agreed upon by and between learned advocates for the parties, list this matter once again on September 17, 2025, marked 3 p.m. And paragraph notes of argument along with copies of judgments filed by the appellant be kept with the records. Respondent be kept with the records.
and they will conclude it on the same day, my lord. That's the assurance we get. I have practically concluded. I will, my lord, possibly show the 2 more judgments which
So
are there.
why don't you do this? They'll have no excuse. Supply them the citations of the judgments.
Yeah, I have given
Oh, all these, acha.
Lunch day handover.
So be prepared, sir.
Yes,
If your seniors are not available, you have this golden opportunity of arguing.
I'll
Prepare
ensure
yourself. Ensure. Chalo.